Your Excellency, Ambassadors, Minister, dear professors, dear guests, my name is Justina Zilinskas and I will host this event. And first of all, thank you very much for coming. Thank you for your interest in our conference. And without many additional words to add how I think the topic important is, I would like to invite our first welcoming guest, is His Excellency Ambassador of Republic of Ukraine to Republic of Lithuania, Beshta Petro. So, Ambassador, the floor is yours. May you please come to the stand.
Labas rytas, good morning. I would like to start with my appreciation to the Mykolas Romeris University for organizing this conference dedicated to the issue of responsibility. And I want to express my gratitude to the government of Lithuania for the strong support on the peace formula of Ukraine, and especially special attention to the responsibility track. Minister Dobrowolska, thank you for your support. And of course, I would like to thank Minister Anušauskas, who will participate in this conference today, for his efforts and for supporting Ukraine on the battlefield. Full-scale invasion in Ukraine started on February 2022, has brought immense suffering to Ukrainians, but also led to a broad set of implications for European security, transatlantic stability and global agenda. We should not forget occupation of Crimea and Donbass in 2014, aggression against Georgia in 2008, and instigation of the frozen conflict in Moldova, which represent a clear picture of the consistent policy of Russian imperialism in Europe in the 21st century. Key objective of Kremlin's war of aggression is to destroy independent Ukraine, to damage security architecture in Europe, and prepare bridgeheads for further aggressive policies in Europe and elsewhere, in Middle East, Africa. Consistent attack by Russia on Ukraine export of food and freedom of navigation in the Black Sea pushes millions of people worldwide into hunger and poverty. Russian occupation of the Zaporizhzhia nuclear power plant and attacks on other nuclear power plants highlight the immense danger to nuclear safety and security, which can bring humanity to another nuclear catastrophe. Another Moscow objective is undermining the international legal order and sowing chaos where no state can be secure, international law is torn to pieces, and international institutions are unable to ensure stability, prevent conflicts, and foster global cooperation on the critical challenges ahead. Chaos is gold for the Russian regime, and human life is nothing. Human suffering is just a tool of Russian imperialistic policies aimed at entrenching authoritarianism, disrupting democracies, and reverting back to spheres of influence, realpolitik, reminiscent of the Cold War. There can be no sustainable peace until justice is established. Ukraine's victory in this war is the only way to restore stability and rules-based order in Europe. President Zelensky's peace formula is a comprehensive plan to restore Ukraine's territorial integrity and to guarantee security and justice. Its 10 points were reflected in the UNGA resolution, UN Charter principles underlying a comprehensive, just and lasting peace in Ukraine adopted this year in February. As you all will know, the greatest instigation of crime is impunity. Accountability for the crime of aggression must be inevitable. We appreciate the efforts of the ICC on conducting investigation in Ukraine for war crimes, crimes against humanity, and crime of genocide. On March 17, the International Criminal Court issued a lifelong arrest warrant against President Putin and Maria Lvova-Belova for alleged war crime of unlawful deportation of children. Ukraine initiated the creation of the core group of states which work on legal and procedural issues of the future special tribunal for the crime of aggression against Ukraine. As of now, 40 states have joined the core group, including Lithuania. A part of individual criminal accountability that will be main task for future work of this tribunal, Ukraine also filed a genocide case against Russia to the International Court of Justice. 32 states, including Lithuania, joined to this case and present their oral statement during the hearing in Hague this September. Last but not least, compensation. On 27th of June, the Conference of Participants of International Register of Damage caused by Russian aggression against Ukraine held its constitutive meeting in Strasbourg. 42 countries, including Lithuania and the EU, have already joined it. The next practical step must be the establishment of an international compensation mechanism immobilizing and repurposing of Russian state assets. Only full responsibility for violations of international law can pave the way to non-repetition by any other state to just and stable future. Full implementation of the peace formula of President Zelensky gives the international community a chance to resurrect foundations of international peace and justice based on international law and capable institutions. Thank you, and I wish you a productive work.
Thank you very much, Ambassador. And now I would like to invite to say a few welcoming words our Minister of Justice, Ewelina Dobrowolska. So, Minister, the stage.
Thank you very much. Excellencies, dear colleagues, distinguished guests, first of all, good morning. In both a great pleasure and honor for me to extend my warmest welcome to each of you at this conference. The title of this conference, Battlefield Ukraine, Exploring War and Justice, raises many questions starting from have we as international community done all we could to prevent Ukraine from becoming that terrible and intensive battlefield? And that happened after the promise of international peace has been made in UN Charter, an act of aggression by Russia has been committed already in 2014. And finishing with the question, what else has to be explored from the justice perspective in the context of a full-scale aggression against Ukraine, so that finally a political decision on the establishment of a fully-fledged international special tribunal for the crime of aggression are undertaken. Justice takes time, and ensuring accountability of international crimes perpetrators has never been an easy task for national justice system. And that's why international criminal law, with its own institution, came into being with the main objective of ending impunity. Lithuania's own experience while trying to ensure criminal justice for international crimes being committed under the totalitarian Soviet rule can be taken as an example, but sometimes searches for justice do take time, and not only because of fading memories. As Justice Jackson leading the prosecution of the side of United States of America in the Nuremberg trial stated, for the incredible events, we need credible evidence. This is why the issue of evidence is so crucial, to make sure that we achieve justice today or tomorrow, as soon as we have agreed legal solution to do it. Therefore, I hope that this conference will explore all that can be done today to make sure that justice does not lose the battle against impunity in the future. Reaction of international community to aggression against Ukraine and consolidated efforts in helping Ukraine to defend itself and fight not only for its own survival and freedom, but also for ours, makes me hope that victory of justice will be far-reaching and having fundamental implication for so needed developments in international law and international criminal law. International law became different after Nuremberg, as individual criminal responsibility was applied for acts against peace being committed by states. Let us all consolidate our efforts on the political and academic level so that international law becomes different after the aggression against Ukraine, including the crime of aggression, does not stay on the paper only. Dear colleagues, ladies and gentlemen, from our history we know that time is essence for the administration of justice. Thus, international community must not get lost in the details and legal deliberation for too long. Because while political solution on special tribunal or confiscation of Russia frozen assets still wait, aggressor doesn't wait. He keeps finding supporters for his brutal aggression against Ukraine, resulting in consequences for the whole international community. Arrest issued by ICC and sends powerful message that immunity doesn't mean impunity. But legitimacy of Russian political and military leadership can truly be undermined only with establishment of a tribunal for the crime of aggression they committed. While final political decisions on a special tribunal are still to come, domestic jurisdiction as Lithuania and other joint investigation team countries have to start sharing burden of prosecution for other international crime being committed in Ukraine by relying on possible universal jurisdiction. Lithuania remains fully committed to ensure accountability for perpetrators of international crime in Ukraine. And we hope that by common investigation efforts, sharing the evidence and expertise in this field, we will soon move from investigation to court proceedings. Long journey to justice consists of small steps being undertaken on a constant basis. Conferences like this enables us to act more, to act differently, or to act better toward the same goal of accountability. And this is why I wish you great discussion about another small steps we can take together. Wish you a great day.
Thank you very much, Minister. And now I would like to ask to play a welcoming message by Arvydas Anušauskas, who is Lithuanian Minister of Defense, but he's currently on his way to meeting with allies. So he sent us the greeting from the screen. So.
Ladies and gentlemen, I'm honored to join in opening this necessary and timely conference. As the Minister of National Defense, I have to notice that the military support for Ukraine is essential. However, the support by the international legal community is no less important. The power of law in defending Ukraine cannot be ignored. We cannot allow the aggressor to abuse an existing legal regime. The end of the World War II was the beginning of the current international legal order. The Russian aggression against Ukraine is also an attack against this legal order. I encourage all the participants to contribute to today's discussion. Together, we can move closer to victory not only for Ukraine, but also for the integrity of international law. Thank you.
So, thanks for the Minister. And yes, just some technical things. And last but not least, welcoming words are from our Dean of Law School of Mykolas Romeris University, Professor Lyra Jakulevičienė. Please, the floor is yours.
Dear Minister, Excellencies, Ambassadors, honorable speakers, dear colleagues, шановні друзі українці, welcome to Mykolas Romeris University. Welcome to our online speakers. On behalf of the Law School of Mykolas Romeris University, I would like to express our very deep and sincere gratitude to all the foreign speakers who managed to come to Lithuania or who will connect online. I would like to express our support our gratitude to the supporters, and of course, Professor Zilinskas, who is the initiator of this very important event. Dear colleagues, today we understand very well, first, that the world is very small, and that the problems that seemed far away, very distant to us, they can appear very suddenly in our backyard. And second, we all understand that global problems, like problems of security, they cannot be handled by one state or even one region, so we need solidarity. In this spirit, we as international lawyers, we consider it essential, very important, to discuss the situation in Ukraine and legal aspects related to it. Today's initiative is not an isolated one in Mykolas Romeris University. It is part of a much broader strategic cooperation of our university with Ukraine. I could mention just few initiatives. We are calculating more than 10 years of cooperation with 3 main universities of Ukraine in Kiev, in Lviv, and Kharkiv. The joint programs, double degree programs, they are implemented for over a decade. We have been hosting as university the Ukrainian school of more than 500 pupils since the time of aggression. And even before February of 2022, we have established in 2018 a center for cooperation to deepen our cooperation with Ukraine on studies, research, and innovations. Of course, those mechanisms that existed and those contacts of cooperation that existed before February of last year, they were instrumental also to provide all various support to our Ukrainian colleagues following the aggression. Needless to say, various academic events to explain to the society what is happening, to explain the legal aspects of it, have been present at university since the first day of aggression. I'm very proud that the first graduates of Ukrainian practitioners, prosecutors, judges, advocates, other legal practitioners have graduated already during last year from our programs for practitioners, from our LLMs. Some of them joined the programs this year. So we also believe that in this way we strengthen cooperation also on the legal path. Today, what we discuss, maybe we cannot implement everything at this moment, but I believe that very soon what we discuss today we can implement in practice. And still, sometimes we face some skeptics who dare to say that international law is powerless, international organizations and institutions are powerless. But for those who still believe in that, who are not convinced in the importance of international law, I could just offer to close your eyes for 1 second and just imagine the world without international law. I believe you will want to open your eyes very, very soon. Dear colleagues, sooner or later, wars, aggression end, and the time for responsibility, for accountability, and for justice comes. And we, as academics, we should not stay apart. Все буде Україна.
Thank you very much. Now, before we will start our scientific discussion, I would like to say a few words regarding technical issues and organizational issues. First of all, I'm addressing those who are online. So whether it's Zoom or YouTube, you can write your questions in the chat. If you wish to participate directly, there also will be possibility, but we would prefer to have questions presented by the chat. Also, for those who are in this room, I would like for you to pay attention. There are QR codes on your tables. These are donations for tactical medicine for helping Ukrainian soldiers who are wounded and need additional equipment. So if you have some spare money, you can donate very easily. I will put these links on donations also on YouTube as well as in the Zoom. Also, we have a slight amendment to the program. You will find it in the second page attached, because for the student session we have a change of the moderator. What else I miss? I think that is all for the organizational matters. So now I would like to welcome the first panel and its moderator, our dear friend, Professor and Dean of Vytautas Magnus University Law School and former President of the Constitutional Court of Lithuania, Professor Dainius Žalimas. Please take your seat, as well as my dear foreign friends, Colonel Professor Charles Garraway, Professor Roman Yedeliev from Kiev, and Tamas Lattmann, professor from New York University in Prague. And in Zoom, we will meet Professor Evhen Tsybulenko from Tallinn University of Technologies Law School. So I wish everyone fruitful discussion, and let's start. Thank you.
Thank you. Thank you very much. First of all, I'm honored and very happy to be here and to chair the first session dedicated to very important issues, including also accountability for the aggression and separate crimes against humanity and war crimes being committed by the Russian armed forces in Ukraine. And I am honored, first of all, to introduce you to Colonel Professor Charles Garraway from University of Essex. He served for 30 years in Army legal services, reaching the rank of colonel. He specialized in international and operational law, deploying with the 1st Armored Division in the 1991 Gulf War. On retirement in 2003, he worked in Baghdad for the Foreign and Commonwealth Office before accepting the Stockton Chair in International Law at the United States Naval War College. Since returning to the UK, he worked for some years with the British Red Cross and as an international legal advisor, and has lectured and written extensively on international humanitarian law, human rights law, and international criminal law. He was a member and vice president in 2012-2015 of the International Humanitarian Fact-Finding Commission, member between 2007 and 2017. And then from 2017 to 2019 was a member of a group of eminent experts for Yemen appointed by the United Nations High Commissioner for Human Rights. His theme today is protection, what is very, really important and topical in the context of aggressive war against Ukraine, that is the protection of objects of energy and critical infrastructure. So, Professor, please, the floor is yours.
I always say there are lies, damn lies, and curricula vitae. But thank you to the organizers very much for the invitation to come. This is my first visit to Vilnius, and I hope it will not be my last. Now, one of the dangers of examining any part of the law is to look at it entirely from one viewpoint. This is particularly true of international humanitarian law, the law of armed conflict. The law of armed conflict is different from the law on the use of force, the jus ad bellum. The law of armed conflict is blind to the causes of the conflict and applies to both sides equally, whether aggressor or defender. This can often be difficult to reflect. We have an ancient saying in English, before the days of political correctness: what is good for the goose is good for the gander. What is good for the female goose is good for the male goose. And when looking at the law, and in particular interpreting it, we must realize that we cannot avoid applying any interpretation that we may wish to make to the other side as well. I therefore want to look at the question of attacks on critical infrastructure, in particular energy infrastructure, from a neutral position, which we can then apply to all sides in any conflict. Imagine for a moment you are a senior commander of a country at war. Your politicians call you in. and say that they conduct a bombing campaign against infrastructure critical to the war effort of the enemy. In particular, they wish to limit the access to energy because this could be used for war activities. In principle, to a commander, this will sound very good sense. But then he goes to see his lawyer. Nowhere in the law of armed conflict will you find the term critical infrastructure. Attacks may only be made on military objectives. These are not only obvious military targets, but are defined as objects which by their nature, location, purpose, or use make an effective contribution to military action. Furthermore, that is not sufficient in itself to make something a military objective. There is a further test. This requires that in respect of that object, the total or partial destruction, capture, or neutralization, in the circumstances ruling at the time, offers a definite military advantage. It follows that each and every target selected in a bombing campaign has to pass this two-tier test. There may be occasions when even what we would all agree is a military object is not a military objective because it fails to pass the second part of the test. An example comes from the first Gulf War, when Saddam Hussein parked a MiG fighter beside the ziggurat and of the Chaldees, inviting the Allies to bomb it. The risk to the ziggurat was large. What was the military advantage of attacking that fighter? None, because it was stuck in the sand and it wasn't going anywhere. So although it was clearly a military object, it was not within the definition a military objective and was not attacked. However, it is here that I must introduce my good for the goose principle. The United States, during the War on Terror, introduced a new interpretation of military objective. And I quote, "Military action has a broad meaning and is understood to mean the general prosecution of the war. It is not necessary that the object provide immediate tactical or operational gains, or that the object makes an effective contribution to a specific military operation. Rather, the object's effective contribution to the war-fighting or war-sustaining capability of an opposing force is sufficient." This far wider interpretation has not been accepted by most of the rest of the world, and even, dare I say it, the US military are not entirely happy with it. However, to extend the definition to war-sustaining industries opens us to something close to total warfare and could easily be interpreted to include all energy by an unscrupulous party. However, it is also correct that the United States is not a party to Additional Protocol 1, where the definition of military objective comes from. And it is therefore stating its interpretation of customary international law. Ukraine and Russia are both parties to Additional Protocol 1 and therefore bound by the specific treaty provisions. Modern life is dependent on technology, and much of that technology is intermingled in time of war between civilian and military use. This is particularly true of energy. It is hard to deny that the production of energy and its distribution does not, in principle, quote, make an effective contribution to military action. On that basis, is it possible to order blanket attacks on energy sources? The answer is no. because we now need to bring in another rule of the law of armed conflict, the principle of proportionality. Once an object has been identified as a military objective, it is necessary to ask whether the attack may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. Let us take, for example, a power station in a remote area of the country where there are no military operations. That power is used to provide essential energy to the civilian population. To leave that population without heat, or in some countries cooling capacity, or light, with consequent risk to life, when little, if any, of the energy produced supports a military effort, is likely to fail this test. On the other hand, an electricity plant close to the front line, which provides direct support to military operations, may lead to a different conclusion, particularly if the civilian population has been largely evacuated. But even proportionality is not the final answer. There is still the principle that the civilian population and individual civilians shall enjoy general protection against dangers arising from military operations. This goes far further than merely death or injury, and is summed up in the responsibility to take constant care to spare the civilian population, civilians, and civilian objects, sometimes described as precautions in attack, is required to take all feasible precautions in the choice of means and methods of attack with a view to avoiding, and in any event to minimizing, incidental loss of civilian life, injury to civilians, and damage to civilian objects. Put another way, if an attack on the electricity plant would cut off supplies to military and civilian alike, is there a way that this can be limited to military only? In many cases, that might not be possible. But it is a question that has to be asked. Is it possible, for example, to attack the power lines, taking the power to the front line, leaving the plant operating, but only able to provide electricity to rear areas where the civilians are mainly to be found? There are specific rules also on works and installations containing dangerous forces, defined as dams, dikes, and nuclear electrical generating stations. We later discussed the Kakhovka Dam, but I have to add a few words on nuclear electrical generating stations. Article 56 of Additional Protocol 1 provides that works or installations containing dangerous forces, namely dams, dikes, and nuclear electrical generating stations, shall not be made the subject of attack, even where those objects are military objectives, if such attack may cause the release of dangerous forces and consequent severe losses among the civilian population. This is not proportionality. This stands on its own. Other military objectives located at or in the vicinity of these works or installations shall not be made the object of attack if such attack may cause the release of dangerous forces from the works or installations and consequent severe losses among the civilian population. There are, however, exceptions. For a nuclear generating station only if it provides electric power in regular, significant, and direct support of military operations, and if such attacks is the only feasible way to terminate such support. Again, a two-part test. For other military objectives located at or in the vicinity of these works or installations only if they are used in regular, significant, and direct support of military operations, and again, if such attack is the only feasible way to terminate such support. I should point out that the UK and a number of other Western states have made statements, effectively reservations, on this article. And I quote the United Kingdom statement. The United Kingdom cannot undertake to grant absolute protection to installations which may contribute to the opposing party's war effort or to the defenders of such installations, but will take all due precautions in military operations at or near such installations in the light of the known facts, including any special marking which the installation may carry, to avoid severe collateral losses among the civilian population. Direct attacks on such installations will be launched only on authorization at a high level of command. This does not, however, remove the requirement to comply with the proportionality principle outlined above. I should point out, however, that neither Russia nor Ukraine, both parties to Additional Protocol 1, have made any similar reservation, and they are thus bound by the clear terms of Article 56. So what have I learnt now as a general? The first thing is it is not as easy as I thought. General attacks on what I, or my planners, may consider critical infrastructure will almost certainly lead to a number of illegal attacks, and indeed could be considered as indiscriminate attacks. If I want to avoid a one-way ticket to The Hague and a visit to the International Criminal Court, I need to be much more discriminate in my planning. Each target needs to undergo a three-way assessment. Is it a military objective under the laws of armed conflict? I have learnt that military objectives is a wider concept than military objects. Will the expected incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, be excessive in relation to the concrete and direct military advantage anticipated? Thirdly, have I taken all feasible precautions in the choice of means and methods of attack with a view to avoiding and to, in any event, minimizing incidental loss of civilian life, injury to civilians, and damage to civilian objects? Finally, in all of this, I must be aware of my obligation to take constant care to spare the civilian population, civilians and civilian objects, as they enjoy general protection against dangers arising from military operations. Oh well, I suppose it's back to the drawing board. Thank you very much.
Thank you very much, dear Professor. I just would like to remind that we will have some 20 minutes or even more for questions and answers after the second presentation. And the second presentation will be made by Associate Professor Dr. Roman Yedeliev, who is from Taras Shevchenko National University of Kyiv. He specializes in public international law, international human rights protection, international humanitarian law, and international criminal law. He holds a PhD in international law from Taras Shevchenko National University of Kyiv. Roman worked as a research fellow at the Institute of Legislation at the Verkhovna Rada of Ukraine. He provides expertise also to the ICRC delegation in Ukraine, Council of Europe office in Ukraine, public authorities, human rights, non-governmental organizations. He was the principal investigator in a state-funded multidisciplinary research project, International Legal and Social Mechanism to Counter Separatism in Ukraine. He spent 1 year as a senior fellow at the Berlin-Potsdam Research Group, International Rule of Law, Rise or Decline. where he researched the lawfare of Ukraine against the Russian Federation. Currently, Roman holds the position of Executive Director at the Ukrainian Association of International Law. And Roman's theme today is private, it is also one of the very important and topical issues in the armed conflict between Russia and Ukraine. That is private military companies and the elusive quest for international law, navigating the shadow. So please, the floor is yours.
How can I navigate the presentation? Sorry for it.
No problem. So, yeah, here you
Yeah, it is. So if it doesn't, it is not a problem.
No, it will.
Oh, so yeah, it works. Okay. Wonderful, yeah. Wonderful. Wonderful.
You need somewhere to put your computer,
Yeah.
right? Okay.
It will be great, but please don't worry. So, dear colleagues, thank you very much for having me here. It's a great honor to take the floor before such an esteemed audience. Many thanks for Professor Žalimas for introducing me. Today I will speak about private military companies and the elusive quest for international law navigating the shadow in Russia's war against Ukraine. Our today's conference topic is Battlefield in Ukraine, Exploring War and Justice. Yeah, my report will be focused on the topic of war, exploring war, and then during students' session it will be a presentation on criminal responsibility of Wagner PMC leaders, and it will be about exploring justice. My report will consist of two parts. The first one, status of the so-called Wagner PMC under international humanitarian law, and the second part will be about general considerations about PMC's regulation by international law. So the first part will be more positive approach to international law. We'll talk about IHL provisions and we'll try to apply them to the Wagner PMC, and then few words about what we have, what we should have, what we can do, and so on and so on. General considerations will be mainly about questions than answers, because you see we have to navigate the shadow, but we have a lot of problems with it. During discussing status of the so-called Wagner PMC under international humanitarian law, I will stop on four issues. Can the members of PMC Wagner be qualified as mercenaries? Then, is the Wagner PMC an armed force of the Russian Federation within the meaning of the additional Protocol 1? The third question will be, do the members of the Wagner PMC have combatant status, and accordingly, are they subject to the combatant immunity and the possibility of obtaining prisoner of war status? And the last question will be about the designation of the Wagner PMC as an international criminal organization engaged in terrorist activities. What does it mean, and whether it removes the combatant immunity? Let's start. Can the members of PMC Wagner be qualified as mercenaries? Yeah, the concept of mercenary is defined in two treaties ratified by Ukraine. Additional Protocol 1, also ratified by the Russian Federation, and the UN Mercenary Convention. Mercenary Convention is not ratified by the Russian Federation, but in any case, definitions are very similar. Yeah, in IHL and in the UN Mercenary Convention, you see a definition of mercenary from Article 47 of the Additional Protocol 1. I'm not going to read it. I'm sure that you know it, and you know that it is very difficult to prove that someone is a mercenary. It is almost impossible to do for Wagner PMC members because members of the Wagner PMC do not meet at least some of these characteristics. Telling the truth, there is no doubt that the Wagner PMC members meet only the first two criteria from this list, and the most obvious discrepancy is that most of the Wagner PMC members have Russian citizenship. That means citizenship of a party to the conflict. This inherently precludes that the application of the term mercenary in its IHL sense to the majority of PMC Wagner members. Persons not holding Russian citizenship who may participate in the armed conflict on the territory of Ukraine meet the criteria of different citizenship from the parties to the conflict. But there are other problems with their being recognized as mercenaries because quite a lot of foreign members of PMC Wagner they are doing it to get pardon from the Russian Federation's president, yeah, and it is not an aim to get some money or to get remuneration, yeah, and material compensation. And material compensation obviously is needed to be recognized as mercenary. So the answer is no. We cannot qualify PMC Wagner members as mercenaries according to current international law. So let's go further. Is Wagner PMC part of the Russian armed forces? The definition of armed forces lays down 4 requirements for armed groups to be covered by Article 43 of the Additional Protocol 1. The military nature of the group, subordination to a party to the conflict, the existence of a responsible command organization, and compliance with IHL. What do we have with Wagner PMC? Wagner PMC is a military group in nature, and it was formed to conduct military operations. Is associated with the use of weapons and has participated in armed conflicts around the world. So, first requirement, we have it. Then, subordination. We have quite low level of subordination requirement in Article 43 of the Additional Protocol 1. And according to this low level requirement, yeah, so it's a quick mention of the presence of an armed group command that would be responsible to a party to the conflict. What we have? The Wagner PMC is state-funded. Russian president directly signed pardon decrees for future members of the Wagner PMC and personally handed state awards to its fighters. And there is also evidence of joint coordination of PMC Wagner's military operations with the regular armed forces of the Russian Federation, such as in the Battle of Severodonetsk. So we have the second requirement. PMC Wagner is also organized and under the responsible command. Yeah, at least before Prigozhin's death, but we are going to speak about it a little later. And the last, but not least, and very interesting requirement to comply with IHL, one cannot imply an expectation of compliance with absolutely all IHL provisions. Yeah, so it should be exact statements that we are not going to comply IHL. Yeah, that we have de facto violations of IHL, it doesn't mean that this criteria is not met. Yes, so Wagner PMC can hardly be reasonably considered as not meeting this requirement for the armed forces, yeah, because it is de jure requirement, yeah, not de facto, because de facto then you should bear responsibility for your actions. So we have to summarize it. The Wagner PMC in the context of the armed conflict in Ukraine, yeah, it is very important to mention, yeah, that PMCs are very different. Activities of PMCs are also very different, and we have to analyze the exact case. And in a situation of Ukraine, Wagner PMC can most likely be considered as a part of the Russian armed forces. Are the representatives of the Wagner PMC entitled to the status of a prisoner of war when they are captured? The fact that a unit belongs to the armed forces of a state within the meaning of Article 43 of the Additional Protocol 1 automatically means that the status of a prisoner of war is extended to the members of such a unit. If we speak about the Third Geneva Convention, we also should pay attention to the requirements set forth in Article 4 of the Third Geneva Convention, and it deals with individuals. What we have in the Third Geneva Convention, we have a new requirement, yeah, because Article 43 was already analyzed by us. Article 4 of the Third Geneva Convention additionally requires that the aforementioned groups belong to one of the parties to the conflict. And it is also, we have to analyze, does the PMC Wagner belong to the Russian Federation? Let's look at the ICRC commentary to Article 4 of the Third Geneva Convention. Cumulatively met two requirements. The group must engage in armed hostilities in favor of a party to the armed conflict, and the party to the conflict must recognize both the group's participation in the armed hostilities and that this participation is in its favor. The first requirement is quite obvious. Yeah, at least in the context of the activities of the Wagner PMC in Ukraine. As for the second requirement, PMC Wagner receives weapons, training opportunities, recruitment, space for its own operations, intelligence and other support from the Russian Federation. All of the above gives grounds to believe that PMC Wagner belongs to a party to the conflict within the meaning of Article 4 of the Third Geneva Convention. And as this group most likely also meets the conditions mentioned in Article 4 of the Third Geneva Convention, the members of the group should be subject to the status of prisoners of war when captured by Ukraine. And it is great that it is a current practice of Ukraine. So Ukraine recognizes members of PMC Wagner as prisoners of war and gives them this combatant's privilege. But we also have an approach. International Criminal Organization. The Verkhovna Rada of Ukraine recognized the Wagner PMC as an international criminal organization by its resolution. The same mutatis mutandis was done by some other parliaments of the world. The VRU resolution mentions that Ukrainian law enforcement agencies are investigating the activities of this group, in particular under articles of terrorism. A logical question arises as to what this recognition means and whether members of the Wagner PMC can be prosecuted in Ukraine for terrorism-related crimes. For example, under Article 258 of the Criminal Code of Ukraine. The recognition by the Ukrainian parliament of the Wagner PMC as a criminal organization does not remove the need to actually assess the status of this group under IHL to determine whether its members are covered by combatant immunity. It is a very difficult question, but the Verkhovna Rada resolution is mainly a political act. And current practice shows that Ukraine guarantees rights prescribed in the Third Geneva Convention. That's why Wagner PMC members may be prosecuted only for war crimes. Few words about general considerations about private military companies' regulation by international law. While of PMCS is not new, the last 3 decades have seen a significant increase in the outsourcing of military and security functions to private actors. Reasons are very different, but it is a fact. Yeah, it is a serious challenge for international law, for international relations, and it is a hot topic. Yeah, what to do with it. It's a fact. I think all you agree. Then, the broad scope of private military companies mean that they constitute a military tool with potentially far-reaching consequences. They often operate outside any conventional legal framework, and their field of activity is expanding. Yeah, so it is the elusive quest. Yeah, we have to navigate shadow. We do not have current regulation of private military companies' activities. And I don't know, is it good or bad, but we are going to discuss it, as you see in statement number 4. But it's also a fact. We do not have current regulation. We may be tricky enough to try to apply IHL provisions to regulate PMCS activities, but it is a tricky approach. You know that Ukraine uses this tricky approach to international law, and we are quite successful in it, but one day it may change. But let's hope that not very soon. The third statement. Despite apparent similarities, not all PMCs are the same. We have at least 3 basic models: South Africa, the United States, and Russia. These states provide such examples. So South Africa is the most close to mercenaries. The US approach Blackwater, yeah, and when state delegates some functions, yeah, to the private military company. And Russia, Wagner PMC, but also they have other private military companies, the most integrated, yeah, the closest PMCS to a state. So, very different. And we have to study each private military company in each case, only on the case-by-case basis. General approach, we cannot find it now. And it brings us to the fourth question or statement: do we need private military companies' international regulation? As international lawyers, yeah, we like regulation. We like conventions. We can tell students about them, yeah, and we like to have exact provisions. But I'm not sure that we need new regulation in a period of crisis. Because An example, yeah, we have mercenary definition, and it creates more problems than gives benefits. Yeah, because to prove that you are mercenary under international humanitarian law, it is almost impossible task. Yeah, because of these 6 cumulative requirements. If we provide approach to private military companies, it may create more problems for us. And IHL should be very logic in its essence to be applied in the battlefield. Yeah, because soldiers, they do not have time to qualify the person. Is it mercenary? Is it private military company member? Is it an ordinary combatant? And so on. So it should be very strict, very logic, very exact definition. And now states are not ready to adopt such regulation. So maybe now we do not need, yeah, we have to navigate the shadow, but through other means. If we are tricky enough, we can apply IHL provisions to regulate PMCS behavior. We can. For Ukraine, yeah, it would be much more easier not to recognize Wagner PMC members as combatants, do not provide them POW status, and to bring them to court under ordinary crimes of the Criminal Code of Ukraine. But it is not the best way to provide, to guarantee justice. 6, IHL as a value. PMC members have never studied how to apply international humanitarian law, and it is a serious problem. With the Wagner PMC, situation is even more difficult. A lot of its members are prisoners, former prisoners, are criminals. And will they obey IHL if they once violated law with almost no punishment? So we have very funny pictures, yeah, that you commit a crime, you go to PMC Wagner, there you commit crime, you go to prison, and then once again you go to PMC Wagner, and it is something like a closed circle. See in this statement, number 6, the biggest problem, yeah, because IHL should be a guideline, should be value establishment thing. The universal jurisdiction and private military companies will have a separate presentation, but it is an option. It is an option because Ukraine can prosecute under the universal jurisdiction Wagner PMC members if they committed crimes in other parts of the world. But the biggest problem is evidence. Yeah? So if PMC Wagner member committed a crime in Syria, we know that he participated in the Syrian war. We know that he may commit some crimes, but we do not have access to a place where this crime was committed. And it is very difficult to prove. It is a criminal process. It is a criminal procedure. You need evidence, but how to get them? And the last, no one knows what is going to happen next. Yeah? Wagner PMC was at the very tops of newspapers. But after Yevgeny Prigozhin was killed, it almost disappeared. PMC Wagner is going to become a part of the Russian armed forces. And it will be a solution for Wagner private military company. Who thought about it before the coup d'etat try of Yevgeny Prigozhin? So we really cannot see what is going to happen next. Thank you very much.
Thank you very much, dear professor. So now I may invite you to ask questions to both of the speakers from the audience first. Sorry. Yes, please.
Right, so I guess I have two questions that interlink with one another for Professor Charles and Dr. Roman. When it comes to infrastructure that is key for survival, as mentioned in Protocol 1 and 2 in Article 54 that was talked about, how do we define infrastructure that is key for survival? Because as we saw in many Russian bombings, they say as indiscriminate bombings, where they attacked various infrastructures that led to the violations of the rights to housing, health, and education. I mean, some of us might take it as a key to survival. And how do we hold these kind of people that abuse the law and abuse the different types of words that are in the law for their advantage?
Thank you. That is a very good question. And I would suggest that you come to London, because on Monday, our Prime Minister, Rishi Sunak, is actually...
I'm from London.
is introducing or chairing a global forum on starvation and objects indispensable to the survival of the civilian population, at which, in fact, I'm also speaking. So you can prepare me for what I'm supposed to say on Monday. This links us back to Article 54, which deals with starvation and protection of objects indispensable to the survival of the civilian population. All of this has to be linked back to the constant care provision and to precautions in attack and to proportionality. Now, there was great debate prior to 1998 as to whether, when you were talking about objects indispensable to the survival of the civilian population, because it was linked with starvation, you were talking about food and water. That has changed. We changed it during the International Criminal Court. So we extended it to all matters that are indispensable to the survival of the civilian population, which could include blankets, it could include medicines, it could include all kinds of other items, depending on the location where you happen to be. Now, as I said, there is no definition of critical infrastructure. So when I was doing my presentation earlier, I did base it on essentially infrastructure rather than objects indispensable to the survival of the civilian population. But you are quite right to draw attention to this separate article, which also applies to the planners, because the planners also not just have to go through all the targeting rules that I laid out earlier, but this is another factor they have to look at. And as you know, I was a member of the group of eminent experts on Yemen, and this particular article, Article 54, was critical, absolutely critical in Yemen, where there is very little, quote, critical infrastructure, but there are plenty of objects indispensable to the survival of the civilian population. So I'm very grateful to you for drawing that to our attention. Thank you.
Thank you. Yes, please.
Good morning to everyone. Thank you for both speakers for sharing your expertise. I have a question for Professor Charles Garraway. Maybe my question is naive, but I would like to ask, is there a room, a possibility for justification for attacking those objects of energy and critical infrastructure in exercising self-defense if aggressor is the first one to attack those objects? So is there a room for justification, like reacting to aggressors' actions?
Firstly, there is no such thing as a naive question. There are plenty of naive answers, but there are very few naive questions. As I said at the start of my presentation, one of the difficulties about the law of armed conflict is it is blind to the causes of the conflict. It applies to all sides, to the aggressor and to the defender. it is said there can be no self-defense against self-defense, but that is part of the jus ad bellum, the rules on the use of force when going to war. Insofar as the use in bello, the law relating to the conduct of hostilities in particular, is concerned, the law applies equally to both parties. And therefore, as I said, what is good for the goose is good for the gander. And just because you are the defender, you cannot claim any special rights under the law of armed conflict to breach the law. It applies equally to all parties.
Thank you. And if I may also, I would like to ask you one question. What about the estimation of attacks against Ukrainian critical infrastructure in the light, for example, of the Convention against genocide? Can it, how to say, reach the threshold of possible breaches of at least the duty under this convention not to encourage or to prevent genocide?
Genocide, again, is a slightly separate subject. It is the crime of crimes. It is one of the hardest crimes to prove in the international criminal legal structure, because it requires proof of purpose and a very high proof of purpose and intent. Certainly, breaches of the law of armed conflict may go towards the evidence to show that there is a genocidal intent. Whether they do or not is a matter for the evidence. And whilst you may start with evidence of the breaches of laws of armed conflict, you then have to go much higher to prove the evidence in relation to genocide. As a former prosecutor, I always like to start at the bottom and work upwards, because it is much easier to deal with crimes you know you can convict of, rather than going for crimes which you would like to convict of, but there is the danger of acquittal.
Thank you. Thank you very much. Yes, please.
Thank you very much for the opportunity. I would just like to make some points here to my great colleagues with marvelous speeches and presentations, and please don't take this wrongly. Just the problem that I have some ideas is telling stories about the quality of your presentation. So, Professor Garraway, you have brought the example of the Iraqi MiG fighter put close to the Zikkurat. And I don't know if I was correct in understanding your point. You said that as it does not bring all the military tactical advantage, etc., then maybe according to your interpretation, that MiG fighter is not a military target. Now, according to my opinion, and just correct me if I'm wrong or if I misunderstood you, this fighter is still a military target because of its nature. Just in this situation, attack of that fighter would cause such a proportionality problem with collateral damage that the attack itself could be unlawful, but still it's a military target. Please tell me if I'm mistaken or not. And then with the other, Roman, you said something, basically you said two things which I found very important. The first one is just something of a enforcement of that. When talking about the potential problems of private military companies, you said that they would cause problems to international law, international relations, and I was waiting for something which I did not get, and I was very happy for not getting it. You did not say that they pose problems with international humanitarian law. And I think, and this is only my opinion, my take on private military companies, I think that private military companies are basically growing to become much more of a jus ad bellum problem and not necessarily a jus in bello problem. Because as we could see with the practice of the United States, we can see it constantly with the practice of Russia with Wagner, that they have the tendency to use private military companies to get rid of responsibility, and sometimes even trying to cover up their participation in jus ad bellum problems, like starting a conflict, like Russia in Syria. In my mind, it was typically a tool of power in the hands of Russia to influence with its interests in Syria. And I think that we may be in an agreement on that, may not. I would be happy to get your answer. And the second thing, you said that Ukraine would be much better off not granting POW status to Wagner. Now, this is a point where I beg to differ. I think that this is the simple way, what Ukraine now is doing. If you grant them prisoner of war status, you just put those guys down to a certain place, which is more or less fit to the criteria of the Third Geneva Convention, and that's it. You just keep them up there, locked up. You don't care with them. They should be okay. Probably most of these Wagner guys are happy to get food and not having to stand back to the fight and everything. They are going to behave themselves well. But if you initiate criminal proceedings against them, you have to collect evidence, you have to put them into your trial, you have to calculate with the possible criticism from the Strasbourg Human Rights Court, etc., so may end up having much more problem if you don't grant them POW status. So I think that in this case, probably Ukraine is not only doing legitimately what it's doing, but also I believe that they have chosen the easy way related to that. Thank you very much.
Professor, so please.
I entirely agree with you. When I was laying out the targeting procedures, I laid out 3 steps. First question, is something a military objective? If it is not a military objective, you stop right there. Secondly, you look at proportionality. If it passes test 1, passes test 2, you then have to go on to the third part, which is precautions in attack. Undoubtedly, in my view, the attack on the MiG fighter would have put the proportionality test in doubt, to put it mildly, because of the risk of damage to the ziggurat. But in my view, it didn't even pass the first part of the test, because you have to ask yourself whether it's total or partial destruction, capture or neutralization in the circumstances ruling at the time offers a definite military advantage. That fighter was sitting there in the sand, it couldn't take off, it couldn't go anywhere, it couldn't do anything. Yes, by nature it was a military object and therefore passed the first part of the test. I don't think it passed the second part of the test anyway. So as a targeteer, I would have put a large cross against it for part 1. But even if somebody had come to me and said, oh, I think it does provide a definite military advantage for us to take it out, and we'd moved to part 2, I would have said, well, you fail there anyway. So you're absolutely right.
Thank you very much for your comments. You see, about the first comment, it would be a problem of application of IHL. Yeah, so states will have to govern their behavior by IHL principles. It is very difficult to guide, to obey principles, yeah, because when you have an exact article, yeah, you have exact rule, you apply it, and it is quite simple, yeah, so we have 2 articles on critical infrastructure, and states are unable to be in line with them. And we want states voluntarily, yeah, to be governed by principles. As for me, it's a difficult task. And about the second comment, and also the first comment, yeah, the issue of responsibility. Of course, currently, prisoners of war statutes makes situation easier, but I am not sure that the Ukrainian society will accept the release of these prisoners of war after the conflict ends. And if we look at the situation from your point of view, yeah, so it seems like we postpone our problem for next years. And I'm not sure that it is the easiest way. We are, at least in the Criminal Code of Ukraine, we have a different definition of the crime of aggression. Yeah, in the Criminal Code of Ukraine, it is not a leadership crime. I'm not sure that it is a correct approach, really. Yeah, so we also have very quite poor Article 438. It is very difficult. It is on war crimes, and it is very difficult to apply it because it is quite blank article. But we could find, you see, terrorism also possible way. Yeah, of course. A right to a fair trial should be guaranteed, but in any case, it will be a problem because of society request to justice, you see, and we also should bear it in mind and to understand that all we want restoration of justice, yeah, all we want accountability, and it will be a problem, yeah, how to guarantee it. Thank you.
Thank you very much. I think maybe yes, please, sorry.
Professor Tsybulenko, who is on the screen, yes, the fifth member of the panel also would like to ask a question. So, Evhen, yes, if you could turn on your mic, let's try if everything is working.
Few moments.
Yes.
By the way, it is also a good point for the possible tribunal regarding aggression to include all the formation of private military companies.
Okay,
yes, we can hear.
So if you hear us, oh, okay, it's feedback. Please, if you want to ask a question for Roman, please put it forward.
Yes, I can hear you. Do you hear me? Because actually I would like rather to make a comment as to the genocide question, because I think it's a bit more important now, because I'm fully agree with our esteemed colleague, Professor Garraway, that it's very difficult to prove genocide. Because indeed it's very difficult to prove the intent to destroy a certain group. And it's actually the main challenge. I absolutely agree with it, but it does not mean that we should not do it. Because indeed, Russian war in Ukraine, it's definitely genocidal war, and it was in particular officially stated by a number of the parliaments. It was started by the parliaments of the Baltic states, Estonia, Latvia, and Lithuania, as well as Poland, who made an official statement that current war in Ukraine is a genocide. And actually, indeed, there are, as we all know, 5 forms of genocide, including forcible transfer of children of the group to another group, as well as deliberate inflicting on the group conditions of life calculated to bring about its physical destruction. And if we're talking about attack on critical infrastructure, which is specifically done at winter time, because Ukraine weather conditions are pretty severe in winter, so it's not only electricity as such, it's also water, it's also heating. We can definitely say that it can lead to the destruction of the group. So it's clearly follows the criteria of genocide. But how to prove the intent? Actually, in that sense, Russia helps us a lot because there were a lot of official statements by the leaders of the country, by the opinion makers in the official press, and we should understand that in Russia is total censorship. So if something is not in accordance with state policy, it will never appear in the state medias. So basically, if they can see something which says that Ukraine should be erased from the history, or Ukrainian identity should be erased, that all, as they called Bandera elite, should be physically destroyed. So it's, I think, a clear proof exactly of the intent to destroy Ukrainians as a group. So that's why I absolutely truly believe that Russia commits genocide in Ukraine. Actually, all forms of that, starting from the killing of the members of the group, causing serious harm. As I said, definitely destroying of critical infrastructure, it's point C. Definitely forcible transfer of children, it's point E. Yes, I understand that to save maybe on the, to stay on the safer grounds, maybe we can do it in parallel. As all we know, arrest warrant for Putin was issued for war crimes, not for the genocide. Because yes, it's clearly easier to prove the fact of transfer of the children and mass deportations than the intent, but I still think they can do it in parallel way. Because if we will stay on the ground that it's hard to prove, probably we should simply cancel the genocide and say that it's unprovable. So that's it. And if what Russia doing in Ukraine is not genocide, I simply do not know what is genocide. Well, and also I have another very brief comment as to the mercenaries, because frankly speaking, I do not agree to the point that the Wagner group do not follow the criteria that they should be motivated to take part for the private gain, because this criteria has a clear objective part which says that they should have salary which is significantly higher than the salary of the combatants of similar ranks and functions. And that's exactly the case, because in Wagner, the fighters, they have salary which is significantly higher than salary in the regular Russian army or in any other armies that are actually involved in Africa, in Syria, whatsoever. So I agree fully with Roman that some other criteria could not be fulfilled, but as to that specific criteria, I don't think it's a problem at all. Thank you.
Thank you, dear Professor. I would like to ask both speakers, do you have anything to comment?
I certainly did not intend in any way to underplay the possibility of prosecutions for genocide. Certainly, there is clear evidence which could be put before a tribunal. But critical infrastructure, which I was dealing with, is a comparatively small amount of that. It only would contribute, it would give us the first step, but no more than going on to the crime of genocide itself. But I certainly did not intend in any way to diminish the possibilities of that being pursued. I'd like to make that absolutely plain.
Yeah, thank you, Professor Tsybulenko, for your comment. Yeah, it's possible, yeah, but if we look exact, so case-by-case basis, yeah, you see a problem is that we even can look at the same private military company, yeah, when operating in different regions, it should be a different legal qualification of the situation, yeah, and it's really difficult, yeah, about compensation, remuneration, yeah, it's quite disputable, and I agree with you. Thank you very much.
Thank you very much, and it's the right point to proceed with the next two reports. They both concern the issue of international accountability for the crimes being committed against Ukraine and in Ukraine. And I am happy to also to recall that one of the places where the issue of international accountability for the crimes against Ukraine, first of all for the crime of aggression, was raised. It was namely Vilnius last year. In May, we had the conference dedicated specifically to the idea of international tribunal for the crime of aggression, and also dealing with the issues of responsibility for other crimes, because it's very also important and always as an counter-argument, what is used is namely the relationship between the possible special tribunal and the ICC. So I'm pleased to introduce you to the next speaker, Associate Professor Dr. Tamas Lattmann. He is the professor from the University of New York in Prague and the Tomori Paul College in Budapest. Also, he worked at the National University of Public Service, previously Zrínyi Miklós University of National Defense in Budapest. He is a visiting lecturer of the Eötvös Laurent University, Department of International Law and other Hungarian universities, and has extensive international relations with the European region. His main field of interest is international humanitarian law, international human rights law, and currently international criminal law, with a special attention paid to modern international criminal courts. He has been mainly responsible for IHL training within the Hungarian military higher education system in the past 15 years. Tamas Lattmann is an author of more than 60 publications and book chapters, co-editor and author of the most popular Hungarian international law textbook published in 2010. He has held more than 50 conference talks and representations during the past years on issues of human rights, international humanitarian law, law of war, and international criminal law. And today his topic is questions related to post-Ukraine, novel application of Article 14 of the Rome Statute. If I am right in recalling, Article 14 concerns jurisdiction invoked by the referral of a state party. So please, the floor is yours.
Yes, thank you very much for the kind introduction, and thank you very much for having me the chance again to be here in Vilnius and talk about this very more of a technical and provocative piece of research at this point, which has caught my attention at the very beginning when the current conflict started in its current all-out war of aggression format. As you can see, there is a slight difference between the titles on the screen now and the titles on the paper. And many of you who do have some experience with conferences, you may get the bad feeling of when you are seeing more question marks in the title already, then it must be that there must be something of a trouble coming. Now, basically, the explanation for all these question marks is the questions and the uncertainties that you pose to yourself during your research, when after some time you start to ask questions, even you're starting initiative ideas about that. And basically, when I started with that issue, it was very nicely fit into my earlier research and publications related to jurisdictional questions of the International Criminal Court. And just kind of like a short disclaimer at the very beginning, referring to the opening speech of the Minister of Defense. Whenever I'm criticizing anything, including the ICC, the prosecutor's office, or whatever, then under no circumstances do I want to use the integrity of international law to protect Vladimir Putin or crimes committed by the Russian armed forces at all. Basically, what I want to do is my arguments and my thinkings and my concerns are about the integric nature of the operation of the International Criminal Court, of international law as it is. Under no circumstances am I somebody who does not want to see individuals responsible standing trial in the International Criminal Court. I want to see them stand trial, but then I don't want those trials to be struck down on procedural and jurisdictional issues because of initiating cases on legal bases which are not 100% sure. So please take all my criticism and everything with this in your mind. Well, let's start with the problem. I don't want to spend too much time with it because I believe that everybody is very well aware of the content of these issues. Basically, we all know that the legal basis of the International Criminal Court jurisdiction the legal basis of the possibility of initiating examinations and then initiating investigations and actual proceedings against specific individuals are pretty well established by the Rome Statute, the founding legal document of the International Criminal Court. But there is immediately a question, which already the drafters of the statute had to deal with, and they dealt to some extent with that. And what about the situation with states which are not party to the International Criminal Court? And that is not really a deciding problem in the current Ukraine-Russia armed conflict, but as my thinking is also targeted to potential future of the application of Article 14 of the statute, of the Rome Statute, which is the referral article, when states party to the Rome Statute can refer situations to the Rome Statute itself, then I do believe that we have to be ready to take this issue as a non-party state, potential non-party state problem, and mostly because basically in the current practice of the International Criminal Court, we see that this is already a thing, that the jurisdiction of the court stands, or does it stand, related to states non-party to the statute. Just, definitely, I don't want to derail my own presentation here, but let me just draw your attention to the ongoing conflict, once again, in Israel with Gaza and the Hamas and the Israel Defense Forces, and the potential role of the International Criminal Court in that conflict. Even if, of course, Israel is not a state party, and probably it will not become a state party for a long time, but the ICC currently now stands on the legal ground of, I do have the legal options to do something. And of course, what we are going to see with Israel is the usual business that Israel and any other country with a conflicted relationship with international courts do in this situation. But I believe that the fact of this is clearly showing us that this question is not going to go away. Even if we feel extremely uncomfortable with that, this question is not going to go away. Now let's take a little bit to this, take a look at the Ukrainian-Russian situation. First of all, neither of these, neither of these states are party to the statute. This is something that can be established at the very beginning. You know, at first we need to build up our bases ourselves. Now, still, the jurisdiction of the International Criminal Court are well established by the unilateral declarations made by Ukraine already much earlier, around in 2014. And I do believe and I do agree with the majority opinion that these unilateral declarations are fully capable of creating the jurisdiction of the International Criminal Court, just as well as the International Criminal Court was completely okay with initiating preliminary examinations, even if the Russian reaction to that was kind of calculatably aggressive, if we may put it that way. You may very well remember that President Putin immediately threatened the world that he is going to withdraw his signature from the statute, like it was done by George W. Bush in 2000. But you know, as I remember, Vladimir Putin has never signed the statute, but it was a very nice threatening towards the world anyway. So of course, this was the political charade part of that. But things have suddenly got a different political dimension in 2022 when Russia has initiated its all-out war of aggression against Ukraine, which has elevated the political dimension of the situation, leading straight to the problem we are going to see. Now, the International Criminal Court has been making examinations before 2022. But I do believe, and correct me if I'm wrong, I believe this is something to be evaluated freely. But I don't have the feeling that the International Criminal Court itself has really taken these examinations hardcore really seriously. before 2022. Just as the political pressure and the political support of Ukraine since 2014 was in a completely different dimension than after 2022. And while I'm not saying that the International Criminal Court tries to play international politics, but I do say that the realities of international politics do have an effect on the actions of the International Criminal Court. So 2022 has changed some things. There is one thing that is very important, that the ICC and the prosecution has had the chance and did use it to a so-called proprio motu initiations. So that means that the prosecutor of the International Criminal Court, based on the unilateral declarations of Ukraine, did get the possibility, and already did get the possibility earlier, to start examination investigations on his, in this case, on his own right. Now, the strange things happened then, which for me was an extremely strange thing. Because I was completely okay with the idea, and I was happy that the prosecutor comes and says, okay, I'm going to do it my own. In one of my earlier studies, one of the first studies related to this in 2009, I have written, and you know, it's very bad with publishing because you can't deny what you had written earlier. I have written that I want to see the prosecutor doing that. You know, I'm a problematic guy. Now he is doing it and I have problems with that. Now I don't have problems with the prosecutor initiating anything on his own because I like it. But I had a very serious problem that really shocked me at that time, is asking for referral by state's party. At the very same statement, when the office of the prosecutor has announced that now we are going to initiate everything proprio motu. That's okay. But on the second sentence, and I would like to ask for referral of the Ukraine situation from member states. My first idea was, why? You have all the jurisdictional basis you need. You have the unilateral declaration from Ukraine. You have the right to initiate investigations on your own right. Why do you ask for a referral? It doesn't make any sense. It's like making it an overkill. Really? Do you need that? So my first question was, why is this needed? Because I did not really understand it from a legal and a political aspect. I think I understood the political aspect, but I have taken this question as a lawyer. My second question was, is this possible at all that states party to the Rome Statute would refer a situation not on their own territory? You know, everything that I was thinking about the International Criminal Court, including the principle of complementarity, was that states may play games on their own territory. States may transfer part or pieces of their sovereignty to the International Criminal Court if they wish to do so, and then we are going to play with issues coming from complementarity and everything, and that's going to be nice. And now what I see is that the prosecutor thinks that the member states could transfer sovereign rights over a territory which is not their territory. Is this really something? Is this a thing? And I still did not understand why it's needed. And the next question is, what are the possible consequences if this becomes a general practice? Because so far, this has never happened according to my knowledge. And then let's see the suspect, Article 14 of the statute. It does say, and based on the text of the statute, it's not impossible. It says a state party may refer to the prosecutor a situation in which one or more crimes within the jurisdiction of the court appear to have been committed, requesting the prosecutor to investigate, etc., etc. Now, everything in this text is fulfilled. I mean, there is the jurisdiction of the court is okay, because the unilateral declarations, no question that there have been some crimes committed which belong to the jurisdiction. So then why did I never see anything like this happening? what we have seen happening during the past years, ever since the Rome Statute is in force, is basically self-referrals. That is what the professional literature started to call it. And I have taken all the practical examples from the practice of the International Criminal Court. All of the cases, all of the situations investigated by the court by member state referral are situations when the member states have referred situations on their own territory, not on another state's territory. So that was the standard practice since 2002. All of these cases are so-called self-referral situations. You may realize that I have a little bit separated Bangladesh from the list. I was thinking a lot of maybe putting Palestine next to it, because in these cases, but it was very clear in Bangladesh, in the situation of Bangladesh. That's also a self-referral, but with a foreign intent. You know, the referral related to the territory of Bangladesh is basically targeting Myanmar and the genocide and crimes against humanity committed against the Rohingyas. So yeah, it's a self-referral, but the target is another state. And Palestine is more or less the same. The state of Palestine, and I don't want to go into a definitional debate right here and now, if it's a state or not, whatever. The International Criminal Court has taken it as such, period, case closed here and now. The political motivation and the intention behind the Palestinian, first a unilateral declaration, and then the ratification, and then the self-referral is, everybody knows, is directed against Israel. But it's a self-referral. All of these are when member states have referred situations on their own territories. And this seemed logical. For me, this seemed very logical. There is one situation, Venezuela, when third state party referrals have taken place, but it has not really grown to be a problem with the International Criminal Court because, cut a long story short, because at the end of this political process and the situation, in November 2021, there was an agreement between the prosecutor's office and the government of Venezuela about closing the open questions. So basically, the court never really had to face the problem, can I take third-party referrals or not? So we have not really been made smarter on this one and only situation in front of the International Criminal Court. So basically, I have left with all my questions myself, which is, let me say, I understand that it's not a community problem, it's only my problem, but you know, when you are doing research, then you have the tools to make your problems to a community problem by doing research and publishing about it. If you take a look at the text of the statement of the prosecutor, that is going to give you all kinds of concerns, or at least I hope it does. The statement of the prosecutor was made public on February 28, a few days after the aggression against Ukraine. Sorry, I correct myself. I do believe that the aggression against Ukraine has started in 2014. This is the all-out war of aggression that we can see. And let me draw your attention to the text of the statement, when even the prosecutor says, it says that I have already tasked my team, etc., everything is okay. An alternative route set out in the statute that could further expedite matters would be for an ICC state party to refer the situation to my office. I have already started doing it. I could do it like this, and this would be much more quick. So please do this for me so that I can take the quick way. Otherwise, I have to go the slow way, which is, okay, I understand it, but I have problems. Seemingly, it's only me having problems. Governments did not really have problems. A lot of governments were coming and putting out the referral. Fun fact, those countries and those governments include the Hungarian government, which otherwise, as you probably all know, My government is not the biggest and strongest ally of Ukraine right now, but still, they have gone with the flow. I would like to report that I was one of the guys advising the government to do that, but definitely you can be sure of that my government doesn't listen to my opinion at all. But luckily there are some other guys who really do have some decency in their thinking related to the matter. So the member states were visibly okay with that. And that is what we have now. That this third-party referral has become live in front of the International Criminal Court. It's the first time ever in the history of the International Criminal Court. And honestly, we don't see the end. And don't get me wrong, I would be very happy to see individuals responsible for the crimes on the territory of Ukraine standing trial, but I don't want the defense to have possible legal arguments for an easy way out from these criminal tribunals. Now, what are the political problems with this? I have just put on my own alert with the time frame. You see now that I'm going to totally ignore it. No, it's 30 seconds. So the first political problem or issue with that is, I clearly understand the reason and the intention and the ambition of putting political pressure on Russia. Believe me, I do that. I like it. I want it. But is this really the job of the ICC to do that? Is this what we have created the International Criminal Court for? You may have your answer. If you say yes, I accept it. I am not 100% sure that this is the good way to the International Criminal Court, because you can see that the International Criminal Court is taking all kind of confrontations with states that it does not necessarily should be taking, but whatever. The next question, is this going to become a new practice? That is what I was referring to in the title. Is it the first wolf, or are there going to be more? Legal problems with that. The thing that I have already mentioned. It's an attempt to avoid judicial control over the prosecutor. It's an attempt to circumvene the judicial control over the prosecutor. And guess what? Professor Garraway could tell us that. You know, it's a very interesting and important thing that sometimes I do have some ideas about how smart I am. I try to find out things, what happened in the past. Well, we have guys who have been there. They can tell us. So one of the big arguments of the United States against the International Criminal Court during the drafting of the statute was that who is going to limit the powers of the prosecutor? I don't care if it's a political argument. It flies well as a legal argument. And now if the prosecutor wants to actively seek to switch out its power limits, then I have to say, and I'm very sorry and I'm very sad to say that seemingly the United States was right at that time, and once again, that doesn't really help the International Criminal Court. Now, what happens if this becomes a new practice, and I believe that this is something ahead of us, which we are going to spend some fun time experiencing it, what will happen to the principle of complementarity? I believe that the principle of complementarity is one of the most unique and most important elements of the operation of the ICC. And basically, that's the token of a successful future of the ICC, because that is giving you the guarantee that states still accept the ICC, including important states like the United States. I would also say Israel, but once again, I'm just alone myself being naive. I believe that these countries, where they have a confrontative relationship with the ICC, they can be qualified as being states working on the rule of law, and if complementarity principle is working fine, these countries should not be afraid of the ICC. Now, if we are killing off the complementarity principle, and we have already started doing that with the case of the situation related to Libya and the UN Security Council referral there, then I don't think that the International Criminal Court will have a long and shiny and bright future with these states. Now, sovereignty, this is clearly a theoretical legal problem. I was already mentioning that I believe that the way how the International Criminal Court can fit into the current legal order of international law which is based on state sovereignty, is that it should respect state sovereignty. And it's an open question if the third-party referrals is in conformity with the current interpretation of sovereignty. Please, don't get me. Don't think that I am an ancient protector of state sovereignty. I'm not. I'm not a big fan of that. But first of all, we don't have anything better. We have that. That is how international law works. We did not invent anything better that is accepted by the majority of the world. And if we actively start to destroy it, I do believe that the consequences are completely unknown to us at this point. So once again, I do support the International Criminal Court. I do support the idea of criminal proceedings against anybody who is responsible for all those tragical and despicable crimes committed on the territory of Ukraine. I just want to do it the right way. Thank you very much for your attention.
Thank you very much, dear professor. And now I'm pleased to introduce next speaker, Professor Dr. Evhen Tsybulenko, who is online with us. So he's an Estonian legal scholar of Ukrainian descent. In 2000, he received a PhD in international law from Kyiv National University. Carried out postdoctoral research at the International Human Rights Law Institute of DePaul University, US, in 2002. In Ukraine, he worked at the International Committee of the Red Cross and the Kyiv International University, where he is a professor since 2009. In Estonia, Evhen Tsybulenko was elected as a professor of law in 2005 and appointed a chair of International and Comparative Law Department at the Tallinn University of Technologies Law School, 2005 and 2010. He has been a researcher at the same school since 2010. Evhen Tsybulenko was a founder and director of the Tallinn Law School's Human Rights Center 2007 and 2014. He is also an adjunct visiting professor and senior visiting mentor at the Joint Command and General Staff course at Baltic Defense College. He published over 40 books and academic articles and more than 200 general interest articles, comments, and interviews. Evhen Tsybulenko cooperates as an external expert with ICRC, Estonian Red Cross, Estonian Integration Commission, Director General for Education and Culture of the European Commission, and the Organization for Security and Cooperation in Europe. His theme today is namely legal challenges in prosecuting the crime of aggression in the Russo-Ukrainian war. So please, Professor, the floor is yours.
Again, hello to everybody, and let me also thank the organizer of this conference. It's indeed a great pleasure for me because I can say a lot of my old friends, and of course special thanks to the Professor Zhilinskas who organized it, and to Professor Zhalimos, who is the moderator of this panel. Actually, before I will proceed with the substantial part of my presentation, I would like to make two general but very important remarks. And I would like to start with very short video, just 1.5 minutes. Forgive me for that, and I will probably ask to switch it on from Vilnius to ensure quality, if it's possible. Yeah, I think you can do it from the chat. It will be easier because it will be in the Zoom. Actually, technically, it was trailer for the documentary, but it itself very interesting, I believe. but it itself very interesting, I believe. I sent you the link to the chat, to the YouTube, so you can simply click it and it automatically, but it itself very interesting, I believe. But it itself very interesting, I believe. I sent you the link to the chat, to the YouTube, so you can simply click it and it automatically, but it itself very interesting.
On the electricity plant would cut off supplies.
Yeah, it is there. I can. Yeah, okay, to everyone, sure. Yes.
Мною принято решение о проведении специальной военной операции.
Just hours ago, Russian forces began their attack.
Kyiv might soon fall to Russian forces.
The Russians will take control of Kiev
within 24 hours.
The Russian force is so much larger than the Ukrainian one.
It's not a question of if Russia takes the capital, it's a question of when.
Can the Ukrainian people stand up?
Ну, максимум 3-4 дня.
Day 6.
Day 33.
78.
Kiev is still standing strong.
Ремейк відомої саги про Давіда і Голіафа.
Putin made a strategic error. The Ukrainian soldiers are fighting for their land.
The Ukrainians want to win this fight.
The Russians have lost about 3 times as much heavy equipment and at least twice as many troops.
Putin did not have much to celebrate on his victory day.
Someone once told me.
Yeah, thank you very much. As I said, I would like to make 2 general considerations. And first, exactly that today it's already the day 632 of the full-scale invasion, and actually almost 10 years of war itself, because it started 2014 with occupation of Crimea, and we definitely should remember that war is not finished yet, and that's why, first of all, I would like to ask all of you to continue to support Ukraine, because we should clearly understand, we should be realists. If Russia will not be defeated, any Russian criminals will not be punished, and all our discussion will be simply a theoretical training of our brains, nothing more. That's why defeat of Russia should be our aim. It should be clearly formulated by everybody. Not something like we should not permit Ukraine to lose, but Russia should be defeated. And after that, yes, we can proceed with international justice as the Russian criminals. And another actually point, second general remarks, I would like to show you this table, which is from the official website of Ukrainian General Procurator Office. And it shows the number, it also exists in English, it also shows the number of different crimes which were committed on the territory of Ukraine by Russian occupational forces. And here, actually, you can see the number of war crimes, which is currently 109,847. Just only think about that figure. And of course, we should clearly understand that without aggression, all those war crimes would be simply impossible, because crime of aggression is considered as a father of all crimes, because it was exactly the starting point of the commitment of all those war crimes. And actually another point is that it's only number which is officially registered by Ukrainian General Procurator Office, and of course it mostly crimes which were committed on the liberated areas, the occupied territories, and we can only guess what's happening on the occupied territories. In Mariupol in particular, where we can see mass graves from the satellites. So we can easily multiply this number for 2 or even 3 times. And what does it mean? It's actually a very important point in the discussion if it's war of Putin, as some people in the West still say, or if it's a war of Russian people. And actually this number clearly shows that it's exactly the war of Russian people. Because all those crimes, they are committed not personally by Putin, Shoigu, or Gerasimov. It's common fathers, husbands, brothers, sons, actually of all parts of Russian society. It's mobilized soldiers, it's recruited soldiers, it's professional Russians, it's so-called volunteers on all levels, starting from soldiers and surgeons through the officers till generals and commander-in-chief. So its entire Russian society is engaged in this war. And it's war crimes. It's not simply if I support war or I do not support war. It's a war crime. That's why we should always keep in mind that Russia should be defeated, and after that the process of de-Russification should be started, similar to the denazification which happened in Germany. Without it, all our efforts will be absolutely useless. Because with de-Russification, I would like to remind you that Russism is now an official term, which was even used in NATO resolutions. And some people say that Russism is Russian fascism, but I can't agree with that because this phenomena is much more deeper. It's indeed a unique combination of fascism, Nazism, communism, actually still, Russian imperialism, chauvinism, and addition of Russian Orthodox fundamentalism. And it's really a very, very dangerous ideology, and it should be defeated as well as Russian state as such. And now let's talk a bit about the presentation itself. So actually, my presentation will be in the same time presentation of our new article, which will be published in very few days. It's already passed the final check in the printing house. So as you can see, even pages now are available. Will be published by the Review of Central and East European Law, which is published by Brille actually. And we tried to discuss with my co-author, Henry Polari, who is also my former student and alumni of our faculty, discuss the possibility how to bring to the justice perpetrators and respectively punish them for the crime of aggression. First of all, Mr. Putin itself, but also his subordinates. Of course, we should keep in mind that it's a crime of high command, but we also should keep in mind that, of course, we should consider not only the full-scale invasion, but the situation which started with occupation of Crimea, which actually started on the 20th of February 2014, and that date was counted on the Russian medal, which clearly shows the beginning date of that war. And it's also very important because Russian propaganda always stated that war started after the flight of Yanukovych as a kind of reaction to that. But that date, which is counted on Russian medal, shows that it started actually before the flight of Yanukovych, and actually this war was planned much earlier, and it was not kind of improvisation or reaction to the Ukrainian Revolution of Dignity. Actually, the article will be divided to the two parts. First one describes the crime of aggression, which is more or less nothing really new for you. That's why probably I will more concentrate on the second part and main conclusions. First of all, actually, I think it's more or less evident, especially after the previous presentation, that ICC in that particular case, unfortunately, will not have jurisdiction because, as we all know, the Kampala amendments, they actually invented much more serious procedural constraints, and in particular, both countries should the member states, which is not the case. And the absence of the jurisdiction of ICC by Ukraine, which is enough for genocide, crimes against humanity, and war crimes, unfortunately, is not the case for the crime of aggression in this particular case. So that's why, unfortunately, we could not use ICC. Of course, theoretically, it could be referral of Security Council, but we all understand that with Russia's presence in the Council, it's absolutely impossible. Actually, the legality of Russia's presence there is also a very doubtful question, as we all know, but of course, we could not go very deep in that issue today. That's why it's very strange for me and very frustrating that Karim Khan, he actually makes a lot of constraints to create a separate tribunal because he believes that it will diminish the role of ICC, but he could not provide any alternative for that. That's why we still need to probably consider other options. And here we have basically several options. One is, of course, a domestic approach. Both Ukrainian courts as well as on the basis of universal jurisdictions, other countries could be involved in that. But here, of course, the main issue will be the power of such tribunal. And another question which will arise as to the regional and hybrid tribunals as well, it's sovereign immunities of the head of the state. Actually, it's a quite topical issue because if we're talking about international tribunals, it should not be really an issue because Nuremberg principle is absolutely clear that in front of international law, states' immunities are not valid. Same thing is also black and white written in ICC statute. But if we're talking about national or hybrid tribunal, unfortunately, situation is not so evident. I personally believe that as we are talking about international crimes, still immunities could be cancelled in such tribunals as well, but unfortunately this approach is not supported by many scholars. That's why the only very safe variant to bring Putin to the justice will be a purely international tribunal. And question is how to create it. Sorry. Actually, the option which was used for the creation of tribunal for former Yugoslavia and for Rwanda for the Security Council is clearly is not the option nowadays because of Russian presence and veto power. And because of that, there are two main possibilities. For a treaty signed by the United Nations and Ukraine on the referral of the General Assembly and the Secretary General, or another possibility to create multilateral treaty between Ukraine and other states, which could be supported by the UN. Here, of course, the main issue, especially if we're talking about first variant, it's a qualified majority vote in the General Assembly, which will not be an easy task. And unfortunately, another problem which we face, and it was already was publicly announced, that unfortunately our Western partners, they are pushing the creation of hybrid tribunal. I don't know why they do not escalate or simply afraid of Russia. It's a big issue for me, but they don't want to create additional international tribunal precedent, and they much more concentrated on the hybrid approach. But with hybrid approach, as I said, the first problem is that question of immunities would be a big problem, so it will be useless to have a tribunal which will not have a possibility to bring to the trial Mr. Putin, because he is acting head of the state. And another issue is that Ukrainian constitution directly prohibits different kind of extraordinary tribunals, and hybrid tribunal will be definitely considered as such. And at time of war, it's prohibited to change Ukrainian constitution. So basically, yeah, probably it's a pure formal question, but it can cause indeed really serious problems. That's why I truly believe that we still should push through the international approach, and probably a voice of the scholars will be definitely very important, explaining politicians why international tribunal probably will be the best option. And of course, as soon as the article will be published, and as I said, it will happen in very nearest days, I will circulate it to all participants of the conference. So, thank you very much, and Slava Ukraini.
Thank you very much, dear Professor. Abusing a little bit of the privilege of being a chair, I would like to ask you several questions, actually two. One may be of legal and one not so legal nature, but because you addressed the issue of a type of a possible tribunal, for me also it's the most logical option is of course international tribunal, because otherwise I can really doubt whether international community is really interested in prosecuting such crimes as the gravest crime of aggression. But don't you think that, maybe how could you respond sometimes to the fears quite widely spread between our allies, especially between those who are not, for example, parties to the Rome Statute, that we are not willing to discuss the idea of, or not to discuss, but to establish, let's say, international tribunal just because it can serve as a sort of precedent, whereas quite widely spread fear that maybe some other countries could establish then also special tribunals for, I don't know, for Iraq war, for example, or for the current war between Israel and Hamas. So maybe it's, how would you respond that it's, you know, shouldn't be used maybe as an obstacle? And the next question, it's more of legal nature, but I think it's my duty since 2014 to recall one specific issue regarding responsibility for the aggression. We all agree that aggression is a leadership crime. The question in the Russian case, it's very specific because also judiciary branch has been involved in committing aggression. I mean, the Russian Constitutional Court, as you are well aware, also played a certain role in decision-making 5 times, by the way, 5 times in decision-making on the annexation of the Ukrainian territories. And when we discuss these matters, you know, the traditional response of they are belonging to judiciary branch, therefore they shouldn't fall under the jurisdiction of a possible future tribunal. So how do you think about their responsibility? Because actually I read all the decisions of a so-called Russian Constitutional Court regarding annexation of Ukrainian territories. It's my impression that they have nothing in common with law. They are purely political decisions. So maybe that can serve a little bit as a sort of argument. So please, Professor.
Thank you very much for your questions, and probably I will start from the second one. I know, and I'm very thankful for your position about the judges of Constitutional Court of Russia, and I'm fully and absolutely agree with you that judicial power in Russian Federation also should be responsible for the crime of aggression, because, yeah, it's definitely leadership crime, but in democratic states, or even in states which pretend to be democratic, we still have division of powers, but all branches of powers, I believe, should be responsible if they are involved in such crimes. So I personally fully support your position, and I believe that judges, it's definitely very essential direction of work after the defeat of Russia, and actually not only judges of Constitutional Court, actually, because Russian judges are also involved in all levels of different crimes, including war crimes, and they're judging, for example, Ukrainian prisoners of war without, of course, any even basis rights for fair trial. And of course, it's not trials, it's just farce and degrading of Ukrainian prisoners of war. So that's why I think that, yes, judicial core and basically judges in Russia on all levels should be definitely under the very precise investigation after the end of war, and definitely Constitutional Court judges should be punished for the crime of aggression. Absolutely agree. As for the first question, yeah, it's a bit more difficult, of course, and as I said, probably it's exactly the reason why our Western partners trying to push through this hybrid tribunal rather than international tribunal. But I think that still, I don't think that precedent could be really dangerous for democratic states because, yeah, I know that there are some attempts to bring America or Israel, but to do it on international level, still it should be certain international consensus. And even if there are pretty big number of the countries who probably would like to do it, but I don't really think that it will be enough for them to create a legitimate international tribunal to judge United States or even Israel. So that's why I think it's more like excuse rather than a real reason, unfortunately. Thank you.
Thank you very much. Now I'm inviting the audience to ask questions. Yes, please.
I have several questions to Professor Lattmann. I had an honor to contribute to Lithuania's referral to ICC of the Ukrainian situation. At that time, we had no knowledge how to do that. And one of the questions was, are there any admissibility criteria for such referrals? Because we tried to look for the other examples. So maybe from your expertise, you have this answer to that question. And another one, do these referrals, recent ones, have any influence on the investigation, which was already had started back then in 2014? Or does this part of the investigation still has to go to the pretrial chamber in ICC? Thank you.
Thank you.
Well, first of all, thank you very much for the question. Let me throw the ball back at you. I mean, you were doing that, I did not. I'm just a guy from all kind of universities and places talking all kind of things. It is you are doing. So basically, I could ask the same question. I think that there is no admissibility criteria in play there, because I do believe that it's up to member states or party to the Rome Statute to make a sovereign decision on that. And as we don't have any earlier practice, conditions, whatever, related to third state referrals, I forgot to mention that during my presentation, sorry, but I was trying to do a quick, a thorough overview of professional literature and everything. And even most of the most relevant sources of the practice of the ICC or the statute, it was a sporadistic mentioning, let me put it like that, a sporadistic mentioning of third-party referrals. So I believe that we are completely in the dark here, which I'm completely willing to agree and to accept, because one of my colleagues back in Hungary told me that I'm completely stupid. This is a clear case. He doesn't even, or she doesn't even understand my problem related. Why could these member states not do that? And looking at the text only, that's absolutely possible. But it doesn't have any practice or anything, so I don't believe that member states, the states party to the Rome Statute, are under a direct legal obligation to consider any criteria here. I think they are free to do that, and my concerns are about the possible consequences of that. But it's very nice to hear that personally you and your team and your colleagues have not found any problem with that. I believe that that basically strengthens the concept and the idea that it's possible and it's workable, and it's time for example, people like me to start seriously considering this, accepting the fact that I have just forgotten that. And not only me. Let that may be something for me. It was not only me, but everybody else. But if that's an option, if we are going to go with that, let's do that. But I don't think that there is any admissibility. I think that what I would think about personally, if my government had asked my opinion, I have no idea what I would have said to them. Because I think that this step may have some consequences, I did not really talk a lot about it, which may not be good. But at the same time, I'm sure that I would have advised my government to go with that. And I'm sorry for admitting it so openly, but why not? We are close friends and colleagues and everybody. But I would have been motivated by political interest, because I want my stupid government to act so bad, like as it does. So okay, try to buy some favors, my friend. So that would have been a political step. And let me be honest, I think it's a political step from all of the governments anyway. So it's not an issue. But I would not have, I would have considered any admissibility and legal issues, but I would have taken it as a political question because it is. And I think that that's the right way to approach this question. Personally, I would have been thinking a lot about the legal consequences. And if we had a government which has an unquestionable report of having close ties to the Western allies and everything, then maybe there is time to come up with legal peculiarities like that. But this is not the time for the Hungarian government to do that. So my motivation would have been like that. But under law, under the current international legal order, I don't see any admissibility. I think that these states did whatever they could in a completely legitimate way. I don't see any violation or fracture or breach of any admissibility or anything related to this decision. And then influence on the already ongoing examinations and investigations. Well, I do believe that basically this referral did not have any actual effect on that, because the examinations have already been going on for a long time. Investigations could have been conducted based on the proprio motu movement of the prosecutor. So this referral was basically really an assistance to the prosecutor to speed up the process and probably to demonstrate a strong political support to this process. which in this case I don't find specifically problematic because I do agree with that political support. Obviously, my answer would be a little bit different if it was another situation, but coming away from my personal opinion, I still believe that even the motivation, the ambition by the prosecutor is something that gives me concerns, but it did not have any effect on the current ongoing processes related to the crimes committed on the territory of Ukraine, I think. But if anybody has some in-house information from the International Criminal Court, I believe that we will be happy to hear that.
Like most of those who spent the summer of 1998 in Rome, in the heat, in a building with very little air conditioning, I suffer from PTSD when I think back to those days. I was one of those who drafted the International Criminal Court Statute. And although I was not directly involved with the jurisdictional...
Okay, sorry, Dom, just for the record, that summer I spent with my civil procedural law exam at the university, and I guess I was suffering the same.
Although I was not directly involved in drafting the jurisdictional provisions, of course I was involved with the rest of the delegation, the UK delegation, in considering the positions. I think the driving force, there was a group called the like-minded states. And the like-minded states thought we will all be like-minded. So it is in our interests to be able to refer to the court. And so Article 14 was actually designed for third-party states to refer other issues to the court. But nobody in Rome actually thought of self-referral. It caught us all by surprise when it started happening. But we were all very delighted. The efforts were really concerned with the proprio motu pars of the prosecutor to try, as you have so correctly pointed out, to tie them down so that we didn't have a rogue prosecutor running wild. I think there has actually been one other case in which the prosecutor tried to evade the, shall we say, the judicial sensitivities. Now, correct me if I'm wrong, but I think the Kenya case, originally the prosecutor said, I could investigate this proprio motu, but it would be much better for you if you self-referred it to me. And therefore he encouraged the Kenyans to self-refer. But he told them, if you don't, I'm going to do it myself.
Thank you, dear Professor. Unfortunately, we're running behind our schedule. So, therefore, I would like to thank, first of all the panelists for very, very interesting and reports and discussions we had here, and thank for the audience for very interesting also questions which can be also continued during the coffee break. And I wish you all good continuation and fruitful discussions in the next session. So thank you very much.
So now please enjoy coffee break, and then we will have student session, and let's be back at 12:20.
Okay. Hello. Let us begin our next session. We are supposed now to have two more interesting presentations till 1 o'clock, but before we start, let me use this opportunity. I was not present during opening speeches, but let me to congratulate and especially express my respect to my colleague, Professor Justinas Žilinskas, because I believe that we should have more of such conferences, especially today in current world, that the issue, Ukraine issue, is still very painful, very important, and it needs to be examined and examined. But in current world, we are losing our patience very fast, and we want new topics. We tend to forget Ukraine, and so it's very important for us not to forget, keep analyzing, keep doing our best to help in academic field Ukraine. So thank you very much, Justinas. And our first title of presentation is assessing the Russian Federation's responsibility for its activities in waters around occupied Crimea in regards UN law of Sea Convention. And I am glad to present our PhD student, Miss Olesia Gorbun. We are very happy to have such an excellent student in our Institute of International and European Union Law. She is not only very responsible and bright PhD student, she is very active. She participated in many international projects of international law, of international humanitarian law, participated in many trainings in international institutions. So she, despite the fact that she is still a student, but she is already very, very close, I believe, to her doctorate degree, and her competence, I strongly believe, is already there. So, Olesia, you are welcome. And sorry, the time frame 15 minutes, then some minutes for questions, discussion, and then next presentation. Thank you.
Thank you for such nice words. Everyone is hearing me, right? I'm trying to, okay. 15 minutes, right? Okay. So, dear participants, I would like to start my presentation with a topic as already was introduced. It's well known, first of all, sorry. First of all, I would like to tell that I'm speaking on my own behalf, and all organization or institution I worked for or was considered affiliated to, not having any opinion about this. So it's my own capacity and my own point of view as a scholar of being a PhD student. Secondly, is that we talked today a lot about responsibility. We talked today a lot about International Criminal Court, and it's well known that there is a state's responsibility. There is articles which was nicely drafted and written by International Law Commission, and it's a draft articles. This presentation is going to be about state responsibility from something which already have, something which international law already established, and it is about convention which does has binding decisions. It's a United Nations Convention on the Law of the Sea, which has very nice part 15, settlement of disputes. In particular, section 2 is compulsory procedures entailing binding decisions. We don't talk, I wouldn't talk about some hypothesis or possibilities. It's very clear. We have a convention which two states could come and ask for justice. So, as introduction already was made, I'll proceed with the historical background Then it's going to be about rights and obligation under UNCLOS, this dispute settlement procedure itself. And the third is going to be Crimean occupation as an issue which we could not to face within this dispute settlement procedure. And the last will be conclusions. The historical background is very clear and known to everyone in this auditorium, or the ones who are probably watching us somehow else online. It's occupation of Crimea by the Russian Federation in 2014. Then, starting from that, Ukraine started its Ukrainian legal warfare. But let's move on the fact that occupation happened, right? This is in the yellow or orangey color, it's exclusive economic zone of Ukraine within its officially internationally established boundaries, and not very delimited in the maritime space in Azov Sea and the Kerch Strait, but still, it's exclusive economic zone of Ukraine. And then what happened within occupation? This picture. It's approximately 73% of Ukrainian water territory generated by Crimea was occupied, and it didn't stop. How to say? It's right now it's under de facto control of the Russian Federation. So then after this, Ukraine started its legal warfare against Russia in different courts and tribunals. That's where it comes cases to the ICJ, ICC, in European Court of Human Rights, UNCLOS, Annex 7 tribunals. To be precise, there is also one case against from Russia against Ukraine in European Human Rights Court, but it was stopped because Russia stopped participating from 2022. So, and then we have a new wave of aggression against Ukraine in February last year, and I guess the reasonable, like how to say, expected question, which I would probably ask someone if I would be sitting here having a background of international humanitarian law and talking about international states' responsibility and laws of armed conflict, why I'm talking about United Nations Convention of the Law of the Sea. It's considered as a treaty which works in a peaceful time, while here it's very clearly, I see the waves, it's aggression. The answer for this, there is no clear answer. Moreover, the fact of occupation is not that much regulated in international humanitarian law. And I believe, from my perspective of view, this case presents an example when UNCLOS is lex specialis and international humanitarian law is lex generalis in this particular case. Why so? Because Ukraine submitted a dispute in 2016 with under provision of UNCLOS, and as it would be in a peaceful time, and Russia accepted the fact and also provided its rejections to their jurisdiction and everything. And it didn't specify there was a legal occupation. Russia didn't say anything that it's considered as a law of armed conflict or anything else. It's two states trying to solve their problems within the Law of the Sea Convention. So let's go to the dispute settlement. It's already 3 disputes, as I mentioned before, between Ukraine and Russian Federation under UNCLOS provisions. First is the dispute concerning coastal state rights in the Black Sea, Sea of Azov, and the Kerch Strait. Then it's a dispute concerning the detention of Ukrainian naval vessels and servicemen. And the third one, it's a provisional measures by UNCLOS, International Tribunal for the Law of the Sea, detention of 3 Ukrainian naval vessels. 2 of them, the first and the second one, the coastal state rights and dispute concerning the detention of Ukrainian naval vessels and servicemen, servicemen are now presented under Annex 7 and the ad hoc tribunals under Annex 7 of UNCLOS, and only provisional measures was made, the decision on it. And here we go to the dispute settlement under UNCLOS, is that jurisdiction granted to that ad hoc tribunal is based on subject matter jurisdiction, rational material jurisdiction, is that a court or tribunal referred shall have jurisdiction over any dispute concerning the interpretation or application of the convention, which is submitted according within the provision of UNCLOS. And here we have the situation when any dispute concerning interpretation, application. Ukraine, while it's making memorials and making the submission, considers itself as a coastal state, which is correct, which is legally right, over waters around the occupied Crimea. And it looks nicely according to legal perspective that it's a coastal state, so it's a convention on the law of the sea. Then the court would have a jurisdiction to rule that if Ukraine waters as a coastal state was violated by activities of the Russian Federation, which is a legally occupying state, it would be a very nice ruling. I wish it would be true. The ad hoc tribunal decided that it's not the case, and indirectly or implicitly it would still has to rule over the fact of occupation of Crimea. And here again, there is some hope. Chagos MPA arbitration, it said that it has very particular phrase which the court can have jurisdiction, which extends to making findings of fact on auxiliary determination of law as are necessary to resolve the dispute presented to it. So, from the perspective of provisions of UNCLOS, the Ukraine as a coastal state could be decided. And the court itself said in some minor issues of territorial sovereignty that could be decided. However, no, it declined jurisdiction, and from the legal perspective, as a Ukrainian citizen, I would be like, why? It's very clear, it's a coastal state. Why the court could not determine that it's a coastal state, it's illegal, everything is clear? No, it didn't. And we could go to the debris of how international arbitration works, how dispute settlement works. I guess the main, as a scholar, I could say that while, for example, in Enrique Alexei, court went beyond its jurisdiction and directly said that it's the case of immunity of the Marines are incidental question to the application of the convention. It didn't say so in Ukrainian-Russia case. The explanation for this I personally found as the fact that if the court would establish the fact of occupation and say that Ukraine is a coastal state, it would inevitably mean that Russia would stop participating in this dispute and say like, no, it doesn't have jurisdiction, and there would be no at all solution. That's why the court went to a different path and established neutrality, where it said it established the fact of a dispute between Ukraine Ukraine and Russia over the waters of Crimea. So we have rights and obligation under UNCLOS, where it's a coastal state, non-coastal state, and we don't have a coastal state. The dispute is still ongoing. It's still going, and the party submits its memorials and its remarks to jurisdiction, to the main procedure. So what is left? Not much, but it's still there. The rights and obligation because of this is very limited. As you can see, the structure of UNCLOS, it's about the maritime zone. So it's territorial sea and contiguous zone, exclusive economic zone, continental shelf, and it's very close to the shore. The land dominates the sea. That's really kind of not powerful, but a popular saying. What is left? In a nutshell, we have a worship immunity, and we have exclusive economic zone, freedom of navigation. We also have territorial sea rights of innocent passage, and in majority, the biggest part why I would assume the tribunal actually left the question, the procedure still going, is environmental protection and obligation to cooperate. That's one of the main articles of UNCLOS where Russia could be brought for responsibility by, for example, construction of the Kerch Bridge, relating environmental protection and obligation to cooperate with Ukraine. So then when it comes to the Crimean occupation, as you see, therefore we have 320 articles, we have 16 parts and annexes, and realistically, right now in the dispute settlement which is going on, right now the court could apply only preamble, Article 2 of Convention, 123, which goes about the cooperation, Part 12, 13, 14, and 15, basically is the parts about marine scientific research, environmental protection, and pretty much dispute settlement itself, the procedure. So what if we can make the court rule over coastal state rights of Ukraine within the Crimean occupation? There is two options. It's advisory opinion of ICJ, and the second one is establishment of the special tribunal. It's been popular today. About the advisory opinion by ICJ, there is already precedent between a country called Mauritius, between UK over Chagos Archipelago case, where first the UNCLOS tribunal, Annex 7 under UNCLOS, denied the jurisdiction, saying that we cannot rule over determination who is a coastal state in Chagos Archipelago. And then Mauritius went to ICJ, went to United Nations General Assembly seeking for advisory opinion by ICJ, and ICJ ruled. And then Mauritius came to International Tribunal for Law of the Sea asking for the continental shelf delimitation between Mauritius and Maldives. And the only thing which is Mauritius and Maldives quite far from each other, if anyone recalling the map, is the continental shelf produced by Chagos Archipelago. And this is the place where UNCLOS ruled that despite the fact that previously under UNCLOS provisions it was said that coastal state is not clear in this case, it said that judicial determination made in advisory opinions carry no less weight and authority than those in judgments because they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with a competence in matters of international law. Therefore, there is one way to Ukraine to actually gain its coastal, to bring Russia to responsibility over its activities in the waters over Crimea. And second is, when I'm talking about establishment of the special tribunal, I'm talking about the fact that the very particular determination of occupation of Crimea starting from 2014 and continuing. So the conclusion will be as follows, I guess, is that we wish international law would work more efficient, more better, and everything. At the same time, a small remark from me that some parts of international law already works. This is United Nations Convention. The other parts already inflicting with it is making it as not efficient. It's reality. It's what we have. And when someone today said that international law powerless and non-efficient, why it exists after 24th of February 2022, my remark would be, we are here and the law doesn't exist by itself. It's all about the human. It's all about the person behind the law. So this presentation aims to show that something could be changed. And as I propose some ways to get it changed, I hope for there to be a better future, but we have what we have. Let's make it use of it. Thank you for your attention.
It's okay, it's very good. So still we have at least a couple or maybe even 5 minutes for our discussion questions. Maybe participants from audience or some remarks regarding this presentation? Okay, Tommy, please.
Yes, thank you. Really interesting presentation. I wish you very much of the luck with the defense of your thesis. I was wondering, since in my thesis I also elaborated the question of lex specialis, and I was really wondering why would you think that UNCLOS is rather lex specialis in comparison with IHL being lex generalis, as we know that ICJ mostly when it had chances to express its opinion on IHL and human rights law, it's usually IHL that is considered as lex specialis, being the law that governs law of armed conflict, and human rights law being lex generalis. So my question is, how did you come up with that idea? And maybe you have something to share.
Thank you for your question. First of all, unlike international humanitarian law and international human rights law, the UNCLOS tribunals or courts are very silent on the fact what they believe is lex specialis or lex generalis in this particular case. I came up with this conclusion based on the fact that occupation is very weakly regulated, especially of maritime zones, not about the land. First of all, one of the mentioning of occupation and its extent and effects is regulated by 1913 Oxford Manual of Naval War, when it's basically a provision that the occupation in the waters is subject to the laws and usages of war on the land. It was in this particular case, it refers to the Hague regulations, and then the question is that the year of establishment of this rule was 1913, while the first talks about the maritime zones started, firstly become by Geneva Convention on the Law of the Sea in 1958, and only after 1982 was UNCLOS established. So UNCLOS in this particular is very, comparing to the international humanitarian law, is kind of newer, and it's more detailed in those provisions. And just like, for example, yesterday was 29 years when it's become in force. It's not that long for international treaty to be in force. Why it's lex specialis is because the state itself acknowledges the fact they didn't, nowhere in the applications, memorials, anywhere mentioned that they believe that international humanitarian law have to apply. So from this perspective, the main focus goes within the UNCLOS procedure. Thank you for your question. It's been a hard question to answer in the beginning, but now I find at least my answers. I hope my answer is good for you.
Okay, thank you, Olesia. Yes, as moderator, I use my authority to stop it here. I know for sure that Professor Tamas Lattmann has much to say. I remember his debate with Tomas Marozas on this topic. But I stop it here because we will go to very, very long academic discussion. And but we postpone this to your PhD defense. And I am glad to present our second title of this session, which is Privatization of War and Liability of Private Military Company Leaders for Complicity to the Crime of Aggression. And I am glad to present the speaker, Romanos Sarantopoulos. Sorry if I mispronounce. He is also very good student. He actually is a student in one of my courses, and I can personally present him as very good student. But again, we are glad to have him in our university now, but he is related to several universities, to international. He's teaching even as assistant in international humanitarian law at University of Rouen, Normandy. Then he is also related to Hague Academy, to the Institute of Higher International Studies of the University Paris Panthéon-Assas. Also, he participated in Jean Pictet competition. Now he is coaching that competition. So all that shows that he has, again, very deep knowledge in international humanitarian law, and his special interest field of research is illegal use of force and implications of non-state actors in armed conflicts. That's why today we have this title. And Romanas, please.
Better? Yeah. Dear Assembly, Excellencies, Professors, and auditors online, I am deeply honored of your presence here today as we are putting a common effort to promote international justice and peace. In this intent, I will be presenting privatization of war and liability of private military companies' leaders for complicity to the crime of aggression, with a case study focused, of course, on Prigozhin and Wagner's role in the war in Eastern Europe. The aggression war led by Russia since February 2022 confirms the failure of the United Nations Security Council to prevent the manifestly unlawful use of force. This war also puts the light on the democratized use of PMSCs, such as done in the Russian-Ukrainian conflict, and of course their fundamental role in political and military matters. Relying on PMSCs has increased the past years, and with the invasion of Ukraine by Russia, everyone became aware of what they are. Often criticized for their proliferation in the violations of international humanitarian law and human rights law, as said by the Working Group on the Use of Mercenaries, PMSCs still represent an asset in escorting and supporting regular state forces. I might seem not that old, but I don't know how this works. Okay. So, aggression in international law got finally criminalized as such in 2010, as you may be aware of, with the Kampala Conference adding a definition of it into the Rome Statute, as you can see on this slide, Article 8 bis, and I'm going to read it for you. It is defined as the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression. The requirement of the perpetrator being in a position effectively to exercise control over or to direct the political or military action of a state remains silent of this person being head of state or non-state actor, such as the leader of a PMC, of course. There is no specific nor mandatory regime on the use of PMCs in international law, and I will refer to the enlightening presentation made by Associate Professor Roman Yedeliev this morning. And of course, as it becomes even harder to control and witness possible violations of international law, the recent privatization of war is a real danger to the objectives protected by international humanitarian law and international criminal law. Thus, it is legitimate and interesting to ask ourselves this question that you can see on the slide. can a private military company's leader be liable for the crime of aggression? In order to answer this question, I have decided to divide my presentation in two parts, with the first one being the definition of the crime of aggression and the evolution it has gone through as the narrower definition of aggression as an obstacle to non-state individuals' responsibility, in order to assess the fundamental role of Wagner's leader in the Ukrainian conflict as the embodiment of control, the political or military action of Russia. So the first part, there are actually two main aspects that I wanted to talk about and are really important to study in order to better understand the origin and the evolution of the crime of aggression, with the first one being the leadership clause as a mens rea requirement, and the second one being complicity's policy level contribution, as complicities for the crime of aggression is different from complicity to other international crimes. So, the leadership clause got interpreted as such by the Nuremberg International Military Tribunal, that I will refer as the IMT, with the crime against peace. I'm not saying that the crime against peace is the same as the crime of aggression, but of course they share common elements that we must study in order to better understand the definition of the crime of aggression. So it is defined as such. In the high command case, as you can see on the slide, it's the high-level position in the government or military as one of the key requisites in determining responsibility. Thus, this is a broader condition than the one used in the International Criminal Court's definition. Moreover, the IMT, and I quote, never questioned the idea that non-governmental actors could commit the crime of aggression. However, the aim of the London Conference at that time was actually to exclude followers from responsibility to the crime of aggression and prevent over-criminalization, a principle that was the spearhead of the Kampala Conference in 2010. In this intent, and I quote, anyone below the policy level is beyond the scope of criminal liability for aggression, rising the threshold to leadership from mere participation to participation of a policy level. The International Law Commission, as we refer to as the ILC, in its draft code of crimes against the peace and security of mankind in 1996, reaffirmed that private sector leaders may be responsible for aggression if they played a decisive role in committing the aggression. Later, they acknowledged that control or direct formulation, as you can see on the slide, was broad enough to include non-state actors into the crime of aggression. This reasoning was followed in 2009 by the working group on the definition of the crime of aggression and kept at the Kampala Conference in 2010. The problem, and my problem, is that with such condition of the definition, it actually seems to exclude non-state individuals from the crime of, from the leadership clause at least. So, in this intent, a group of professors and experts supporting the creation of an ad hoc tribunal criticizes this new formulation and adopted at the Kampala Conference and claims that, I quote, those who materially contributed to or shaped the commission of that crime should be prosecuted without limitation to state leaders. The position of Christian Wennerweiser, as you may know him, permanent representative of Liechtenstein to the United Nations and chair to the Kampala Conference on the definition, could represent an opening on the re-widening of the condition of the leadership clause. And I quote him, Kampala is certainly not the end of a process, it is not the culmination of an effort that we have made. So, to prosecute a non-state individual for the crime of aggression, it could thus be more interesting to do it for complicity. And this is where, this is where the policy level contribution for complicity to aggression is really important to study. So, complicity is to be understood as you can see on the slide, a particular way of contribution to a wrongdoing and assist or influence the perpetrator's conduct. Of course, these elements do not exclude the perpetrator or the accomplice from the element of policy-level contribution. In the IG Farben case, as you can see on the slide, leaders of business entity equipped and provided substantial material to the Nazis. Although this was not deemed enough to qualify the complicity to the crime against peace at the time, Wagner's direct preparation and participation in the hostilities may be relevant to assess Prigozhin's policy-level position or influence the perpetrator's conduct. Although for the moment it is hardly possible to assess the vital role of Wagner in the decisive formulation of aggressive state policy, investigations could lead to such a possibility. The usual control theory used in the Tomas Lubango case is not relevant regarding the crime of aggression, as the nature and degree of control differ from the ones required for other international crimes, as I said before. For Mykolas Romeris, and I quote, "The difference between perpetrators and accomplices in the crime of aggression lies not in the degree, but in the nature of their causal contribution." By stating so, Mykolas Romeris implies that complicity to the crime of aggression does not require less contribution, but a contribution that would fundamentally influence the military action of the state. Prigozhin may satisfy the complicity condition by being able to decisively influence the formulation of the state policy for the act of aggression, but also by committing it. Therefore, it is crucial to factually assess at least, the position of Prigozhin in Russia's political hierarchy and system and his significant role in the aggression. So, in this second part, that I decided to divide in two subparts, the first one being the original extended role of Russian PMSEs, as we had a small introduction by Associate Professor Roman Yedeliev on that matter, and the second one being Wagner's structured commandment as defining state leadership. So the position of PMSEs in Russia is quite different from the one that we have in Western countries. They actually share an equal position with regular states armed forces, although they have been kept illegal under Russian domestic law with the vote of the Russian Duma in 2018, as you may be familiar with. Their role goes beyond this statement, as Valeria Boval affirms they are some sort of governmental structures, a tool of the state's foreign policy. Moreover, Major General Sergei Ganchukov, former head of Siberian Military District Intelligence, considers that these structures are free to choose any means at their disposal to achieve their specific objectives. Russian PMCs have been admitting a central role in Russian geopolitics by achieving many military successes. To illustrate, Wagner operates in different regions of the globe, in Middle East, in Central and Sub-Saharan Africa, but also in Latin America. And Wagner has also been present in Ukraine since 2014, run, equipped, and organized by the GRU, the Russian Military Intelligence Agency. Wagner had a certain political and military control over a large theater of operation in the region of Luhansk in the east of Ukraine. Although its ties with the Kremlin have regularly been denied, attacks on Ukrainian soil have been coordinated with the regular Russian army, and in addition, some sources consider the importance of Wagner soldiers for Russia with the arrest of 33 presumed Wagner soldiers arrested in Belarus in 2020, creating a small-scale crisis between the two countries that are supposed to be friendly to each other. With this legally ambiguous status, Wagner serves a useful deniability, allowing Russia to be present internationally without having to engage its responsibility. A relevant question that we have to ask ourselves in this context is, when the actor is in fact acting on behalf of or under the control of a state, does this very element prevent the non-state actor to direct or control the political military action of the state? In any way, the threshold to prove that a non-state actor is acting on behalf of a state is very high, as indicated in the Latysh case, as you may be all familiar with. I hope so. If Russian regular armed forces coordinated operations with Wagner, Wagner becomes a de facto state actor. Consequently, Prigozhin's position in Wagner would make him able to direct or control the military action of the state. Thus, it is important to study the Wagner structured commandment as defining state leadership. Wagner Group functions according to a command and control system, which is actually pretty complex, and I'm not going to go in much detail about it, but it's operated by Utkin and Prigozhin. The rise of Prigozhin's influence after the Syrian war accorded him a special seat among Russian elite, making him an important asset of Russian foreign policy and allowing him to take over the PMSE of Wagner Group. Although some state that Prigozhin still needs governmental approval to direct Wagner, I would say the opposite. He's actually in a position to control his forces and is in fact independent from Kremlin's endorsement. And the perfect illustration of such control is the ability to pursue his own vision in the rebellion in 2023. Prigozhin's coup reshaped Russian politics, dimming the Wagner's influence over Russian internal and external policy. Moreover, the ability of Prigozhin to publicly defy Russia's defense minister Shoigu on numerous occasions and on military matters regarding the war in Syria and in Ukraine shows that he has the credit of the highest level position in the unofficial hierarchy of the Kremlin. Moreover, the Deir ez-Zor attack in Syria, as you may be familiar with, led supposedly only by Prigozhin and not the Kremlin, who denied ties with the forces, is seen as a major turning point in the relations between Wagner and Russia. The capability to engage forces entailing into significant political consequences for Russia, even with the deniability of such action, proves that Prigozhin had, at least during the time of the Syrian conflict, the ability to control Russian foreign political action. Correspondingly, Prigozhin was able to attend Central African Republic peace talks in Sudan with an entire system based around him to control national security over there. Prigozhin also played an important role in public opinion. In fact, he was still popular after his coup, with 30% of Russian population considering him positively, and before his coup, his popularity even rose to 55%. Of course, these polls were made by Russian entities, so we can ask about the validity of them, but in any way, as you may know, the rebellion still failed and he is presumed dead. In conclusion, the ability to prosecute a leader of a PMC for the complicity to the crime of aggression remains narrow and perhaps impossible. In this situation, not only because Prigozhin is obviously dead, but in a broader sense, because the threshold of control of a PMC leader is significantly high. Although I personally think that it could have been a possibility by an ad hoc jurisdiction with a slightly different interpretation on the crime of aggression, the ICC would struggle to qualify a PMC leader as a perpetrator or an accomplice of the crime. I will say also a small metaphor that might cost me the death stare of my professor, but I will say that when talking about PMCs, international criminal law and the crime of aggression becomes a Rolls-Royce that never leaves the garage. Further and thorough investigations would be needed to confirm a PMC's leader policy-level influence over the Kremlin at the commission of the aggression. On the other hand, the presence of Wagner in Ukraine since 2014 is a fundamental element in assessing the preparation and planification, but also execution of the act of aggression. If Prigozhin was involved in the decision of the act, of course. The culture of impunity among PMSs remains, and the long-lasting efforts to draft a definition for the crime of aggression from Litvinov project to the Kampala conference may have blinded international jurists, disallowing them from foreseeing the evolution of armed conflicts as they should have. Of course, I can provide you with some sources that I used for this presentation. And finally, I would like to express my deepest gratitude to Mykolas Romeris University and to Professor Zilinskas for giving me the opportunity and honor to present my thoughts on such important matter in front of this distinguished assembly. And I believe that our collective efforts will continue to drive progress in obtaining international justice. Thank you for your attention.
Thank you very much, Romanos. So, still some minutes for questions, remarks. Please, Tamas.
Yeah, just a very quick question, more of a request for clarification to your presentation. Am I right, or I'm just missing something here, that you are completely sure that you differentiate between military leaders and private military company leaders, and you don't want to apply the same thing with military leaders?
What do you mean by this question?
I believe
if Prigozhin is the same as Shoigu, that's what you mean?
Yeah. So the point is, I guess, that we all understand the difference between people working in the military and civilians taking some kind of contractual relationship to the state. Yeah. What I want to understand that your ideas and your thinking is, I think it's valid, and it opens a lot of doors, which many people are going to be freaked out if you keep those doors open, but that's fun. So please do that. But really, if it's okay, because I guess we are in agreement that members of PMCs are more of civilians.
Yeah, of course.
And then I understand your point. And I, to some extent, I agree. But then you don't want to apply the same approach with military leaders. I mean, you are talking about someone of a leader of a private company, and you say that he is complicit in the crime made by the political leader, right?
Yeah.
And then you argue, and then you say that you don't apply the same measure with military because military is working in a strict order. But I'm just asking a question. I'm not saying it's wrong or right, just a clarification.
Yeah, no, of course. We have to keep in mind that the leader of a PMC is, first of all, a civilian, and also that, of course, Prigozhin would never be actually military. But we have to assess the facts, and that the fact that he was maybe essential to the formulation of the act of aggression at the policy level influence. Disregard of him being a military or political, either of the two actually, would make him liable for the complicity to the crime.
Okay, but you would not apply the same thing with a general.
I mean, a general, it's kind of easier with Shoigu, for example. I mean, he's the head of the military of Russia, so of course this will not be such a difficult question to assess.
Because usually, high-ranking officers, generals, etc., for example, when they are in various countries, you have these special situations like a defense council or whatever, which are created for wartime situation. In many countries, the military presence there is with the consultative rights. They don't have the right to vote because they are not elected by anybody. So that's kind of logical thing. Like in the US, you have the Joint Chief of Staff. They advise the president, but they don't make a vote. They don't decide. That's a decision by the president and the Congress. Yeah. Those are the political decision makers. And I agree that you want to put civilians into that circle, saying that they have an influence over the political decision. But then my provocative question, don't the military staff have the same influence? And then we are just exempting them from this because now they are military.
So I guess this is not, well, actually, my point was about mere influence. So I wasn't trying to talk about military people or civilian people. It was just about non-state actors, which I think was the main element here. And we have to keep in mind that I was limited by the number of characters that I had to put in the presentation, of course. But I am happy to receive constructive criticism. And
it was not criticism.
No,
clarification here.
No, this is why I'm here, actually. Just a master's student, so I'm ready to discuss this situation with people that know better than me. So
no, don't get me wrong. I did not say. I said that I agree with most of what you said. I was just interested in the territory that you are willing to walk. That's it. Thank you very much.
Thank
you. Thank you very much. Very interesting discussion, and my also opinion that it's not criticism, just, it's more a remark about the role of Prigozhin. Theoretically, your presentation about other private military leader would be okay, but as Prigozhin has kind of double role, I would say even triple role, he was also kind of propaganda leader inciting to war crimes. You can use also this for one more part of research for his complicity for those crimes. But if to take theoretically, all you said is, I think all of us share. It's just another idea how to investigate the role of Prigozhin. So thank you very much, and I give back word to organizers in order to give us information about lunch.
And about the typo in the program.
Okay, so first of all, thanks for Professor Ewelina Zbiaksha for moderating this session. And now I'm announcing we are breaking till 2 p.m. And yes, please enjoy this time. There's still plenty of food out there. And for the, let's say, for the speakers, there will be different instructions, but later. Okay. So hello everybody one more time. I hope you had your break, had your lunch, and now we'd like to continue with our conference, and we would like to start afternoon session. And this time I would like to invite Professor Francesco De Santis, who is an old friend of Mykolas Romeris University, and it's always a pleasure when he's coming. But now I will present his experience because he holds PhD from University of Naples, Federico II, where he is currently serving as Associate Professor of Civil Procedural Law at the Department of Law. He also served at University of Naples since 2009 as researcher, and since 2015 he has been teaching procedures for the international protection of human rights at the Department of Law. From 2011 to 2014 he was a lawyer at the Registry of the European Court of Human Rights. He is an expert on human rights protection and judicial systems for several branches of the Council of Europe, such as European Commission for the Efficiency of Justice, the Department for the Execution of the Judgments of European Court of Human Rights, the Human Rights National Implementation Division, and Human Rights Education for Legal Professionals Program. He's also a practicing lawyer at Naples Bar, and frequently involved in professional training activities for lawyers and magistrates. And he is HELP certified tutor. So, dear Francesco, the floor is yours.
Thank you. This view. Yeah, it's working. Slideshow. From here. There we go. Okay. My honor to be here, dear Justinas. So, why we are here today, and which is my little contribution to this interesting conference. So let's try to frame the topic. Role of non-criminal justice in ensuring a certain degree of accountability in times of war. So accountability in meaning legal responsibility, no political responsibility, being held responsible for something. Gross violation of human rights. Why did I take this approach? Why I think it's useful to take also human rights approach. Today we have elaborated a lot on international humanitarian law, why also human rights. The possible overlapping of humanitarian law and human rights law does not entail that human rights law does not apply at all in times of war. I know this is a long-lasting and discussed subject, the relation between human rights law and humanitarian law, but here I would just like to remind that both set of norms, even if they have slightly different origins, they finally both aims at protecting the value of human dignity, even in this tragedy, which is war. So, and furthermore, let's bear in mind that international humanitarian law has some loopholes. It does not ensure compensation for victims as such. Last but not least, in some legal system, is not considered as part of the national legal system. It's a classical international regulation, so among nations, right? Both violations we are talking about today, as we have already heard, they might, with gross violation of human rights, they also may be qualified under international criminal law as being war crimes or crimes against humanity. But I put my focus on non-criminal justice because it is my background. Of course, I think that everybody should speak of what is in its own expertise and due to my professional experience. It's very interesting. I've learned a lot. I understood that this perspective, the criminal perspective, entail
quite a few difficult legal and factual issues. I take here a complementary perspective, that of state responsibility, so non-criminal but state responsibility for gross violation of human rights perpetrated during the Russian aggression of Ukraine. So, which is the aim of this perspective? Establishment of facts, the truth, then acknowledging human rights violation and compensating victims. I put the focus on victims, and it's more or less the same vein of the basic principle of United Nations, on the well-known basic principle on right to remedy and reparation for victims of gross violation of international human rights and serious violation of international humanitarian law. So, role of justice. Won't deal with reparation schemes settled at the end of the conflict. Usually at the end of a conflict you have treaties among belligerent states, embracing also all claims that nationals may have acquired on account of those conflicts. Usually there is a payment of lump sum from, let's say, one state to another, and then it is for the receiving state to distribute and to assess in the criteria for distribution among his citizens. I won't deal with official apologies. I won't deal with possibility of intervention of some UN committees. Yes, of course, International Committee for ICCPR or CAT. Essentially, they cannot express binding judgment. They don't deliver judgments. They express non-binding views. Last but not least, of course, the International Court of Justice is a court, but I decided, first of all, I don't have such a deep expertise in International Court of Justice, but for sure, states can bring case before Court of Justice, while, as we will see, nowadays we consider possibility of victims of human rights violation to bring their case as part of human rights protection. So I take rather the point of view of victims' action in justice. There is issue of jurisdiction, which is currently discussed on the case Ukraine versus Russia. Last but not least, ICJ does not award compensation to victims again. So that's why we don't cover this subject today. So I cover two main aspects. European Court of Human Rights on the Russian aggression of Ukraine, what it could do and what happened over there in Strasbourg, the Sleepy Beauty, and civil actions for human rights violations. So let's start with European Court of Human Rights. Why I think it's natural to look at Strasbourg? Because it's the last resort for human rights violations in Europe. The Council of Europe as such and the Convention on Human Rights, they are both grounded on the idea of peace and justice. Peace upon justice. Members to the Council of Europe are, I quote here the preamble of the Statute of the Council of Europe, convinced that the pursuit of peace based upon justice and international cooperation is vital for the preservation of human society and civilization. And the same, mutatis mutandis, is in the Convention. And, quite interesting, the European Convention on Human Rights does not disappear in time of war. We have a very nice fact sheets drafted by the Registry of the Court on all the cases of the Strasbourg Court related directly or indirectly to war situation. And there is case law on the Strasbourg Court of this relation between the Convention and humanitarian law. So we can assume that the Convention is still there, even in times of war. And somehow this is confirmed by Article 15, possibility of derogation in times of war. Derogation cannot justify, torture cannot justify inhuman or degrading treatment, slavery, deprivation of life, except as concerned the latter, in respect of deaths resulting from lawful acts of war. So the Convention is there. In addition to this, I invite you to read this important interstate case of 2014. It's exactly about an aggression of Turkey to the northern part of Cyprus. We had first a judgment on the merit, and then this Grand Chamber judgment of 2014 award by the Grand Chamber of just satisfaction to two groups of victims. So interstate case, you see from the name Cyprus versus Turkey, but award of just satisfaction as a punitive damage in favor of two different groups of victims by the Strasbourg court. And I recommend you to read the concurring opinion of Judge Pinto de Albuquerque, saying by this judgment the court says something very clear. Member states that wage war must be held accountable for that and must pay damages to victims. And the Sleepy Beauty was not actually that sleepy at the beginning of the aggression of Ukraine by Russia, because here I just want to quickly remember two interim measures adopted by the Strasbourg court in a few days, actually. So the invasion, if I'm not wrong, was from the 24th of February on the 1st of March, which is like almost immediately for the time, operational time of the Strasbourg court, we had the first interim measure issued by the Strasbourg court, indicating to refrain from military attacks against civilian objects, and so on. Just go quickly. And on the 4th of March, they added something. They say you should ensure access of the civilian population to safe evacuation routes, healthcare, food, and other essential supplies, rapid and unconstrained passage of humanitarian aid and movement of humanitarian workers. So Strasbourg court said something, tried to do something. At the same time, it might be considered a bit naive, if not useless, to look at the Strasbourg court regarding Russian aggression on Ukraine, because as everybody knows, by a resolution adopted on the 16th of March 2022, the Committee of Ministers of the Council of Europe decided that Russia has ceased to be member of the Council of Europe. As a result, consequently, pursuant to Article 58 of the Convention, which says any contracting party shall cease to be member of the Council of Europe, shall cease to be party to this convention, the Strasbourg court say, okay, now Russia is not a member of the convention anymore. Since 16 September 2022. But bear in mind this date, 16 September 2022, while the aggression started in 24th of February 2022. It's still interesting to look at Strasbourg for two different sets of reasons. On the one hand, Russia is still legally bound by the obligation to respect human rights set forth by the Convention till September 2022. So we, after the decision of the Council of Europe to exclude Russia from the Council of Europe and the consequent abandon of the Convention by Russia, still Strasbourg Court works on Russian cases. They issued other interim measures. There are procedural decisions on pending cases regarding Russia, and this will last for years, I think. Not only that, the Strasbourg Court say, I'm still competent to deal with these cases, and they adopted some measures in order to, some practical measures, because on the contrary, the judge elected in respect of Russia does not sit in the Strasbourg Court anymore. And Russia will be obliged to execute the judgments of the European Court of Human Rights, pursuant to Article 46. The Committee of Ministers even said in another resolution they will not participate to the meetings of the Council of Europe. They will just be informed of, so they will just take notes of situation ongoing, providing us with information, but they will not have right to vote, to sit at the Committee of Ministers and to vote on that. Of course, when I talk about executing the judgments of the European Court of Human Rights, just to be clear, judgments of the European Court of Human Rights are executed on the basis of the bona fide cooperation of the defendant state. So in order to have an execution of the judgments of the Strasbourg Court by Russia, we have to think of a time when there will be a regime change in Russia. Let's put it very clearly. There is also another reason why to quickly look at this dimension. Let's bear in mind the situation of Russia before the Strasbourg Court. A few interstate cases, all stemming from armed conflicts launched by Russia or occupation of neighbor countries or some regions of neighbor countries, okay? Ossetia, Abkhazia, Donbass, then Crimea. In the past, there was Transnistria, but it was not an interstate, okay? 17,000 pending cases, quite a few gross violations of human rights acknowledged at the time of the two wars in Chechnya, and also in the administration of Chechnya. Systemic, consistent, and long-lasting difficulties in ensuring respect for Strasbourg core rights. What does it mean? That what happened in February 2002, it's not, well, it's not suddenly. We're discussing today with our colleagues. We didn't want to look at what was already there. So this is a lesson from the past and for the future. Lesson for the Council of Europe. Council of Europe cannot pretend to find always an appeasement with member states. It should put a red line and say, okay, when you cross this red line, I start barking. It is interesting in this respect to read the 2023 report of the Secretary General of the Council of Europe saying what happened in February 2022 was the result of democratic backsliding in Russia. Okay, backsliding is something happening in years. Okay, it's not something happening out of a sudden. Okay, made a bit of a disaster. Sorry, let's get back to the slide. Okay, and it's a lesson what happened in 2022 also for other democratic European states, other state members of the Council of Europe. That's democratic backsliding, meaning refusal to respect European human rights standards, risk to lead to be aggressive with your neighbors. Actually, it's everything, all the human rights law in Europe comes from that assumption. When you do not assure democracy and rule of law in your country, sooner or later there is the risk that you turn and you fight against external enemies. Okay, second part, I go quickly, of my presentation is about civil actions before national court. So the scenario is more or less the following. An individual brings civil action against a state before a national court, alleging that the defendant state committed a gross violation of human rights and the individual claim to be awarded damages. We have this perspective again in the basic principle of United Nations. It's in point 8, access to justice, which include access to national justice. Just bear in mind that usually you can have access to international courts after having exhausted national remedies. Main features of this kind of initiative. Contemporary individualism. Honestly, as people of our generation, we rely less on the initiative of the state. We want to fight for our rights. We want to have a forum to defend our rights. Exclusive forum on the victims and their quest for justice. Use of, which is a bit complicated. We use private law tools, tort law, in order to ensure a certain enforceability of international human rights law. And these actions, this is a big advantage, they don't need to identify the author of the violation. You just bring the case against the state you accuse of having author of a gross violation of human rights. And those actions are filed years or even decades after the events. I would like just to provide you with some examples, but first of all, let's bear in mind which are the main obstacles which this kind of action can face. Depends on the forum chosen. First possibility, lodging, bringing the case in the state who is allegedly the wrongdoer. In our case, we should imagine to bring a civil action before courts of Russia. That's why I don't cover this aspect, because we should assume that one day, as a result of a regime change, we will have not only a fully committed democratic state, but also a state who does not invoke this doctrine of judicial abdication I have made reference in the slide, this act of state, act de gouvernement, acto politico, which are usually used by courts, national courts, not to adjudicate on this kind of cases. They say these are not, it's not something which should be discussed before a court in a jurisdiction. If, which is the examples I would like to discuss a bit, one summon the foreign state before a national court of another state, which we call the forum state, the action will be confronted to and may be barred by the foreign state immunity from jurisdiction. And I think it's, at least for this, it's good to having an Italian lawyer here, because we had quite an interesting experience, as most of you might be aware of. We have this Ferrini litigation. Mr. Ferrini used to be deported, so it's a litigation, it's a case starting in 1998 for deportation at the time of the Second World War, 50 years before, okay? This guy he brought an action before Florence District Court saying, I've been deported, this is, and I was forced to work in a concentration camp, this is a war crime, and I want damages for that. 2004, the Italian Supreme Court set aside the immunity from jurisdiction of Germany. It said, on one hand, we have immunity from jurisdiction, rule of customary law, but on the other hand, we need to protect fundamental human rights. So we have to put these two needs in balance, and I think it's more important to offer a forum for protection of human rights. Then, increasing litigation of this type, foreign judgments from Greece, for instance, for Greek, for instance, the distomo. Human rights violation happening, which happened in Greece at the time of the Second World War, enforced in Italy or recognized in Italy. Germany reacted, the International Court of Justice said, no, there is no need to discuss this state immunity from jurisdiction. So Italy, by this litigation, by the Ferrini case law, is violating international law. And the Italian Constitutional Court in 2014, judgment number 238, said, we are sorry, but we don't discuss the existence of this rule on state immunity from jurisdiction, but insofar as includes acts amounting to serious violation of international law and fundamental rights, we say that this rule does not enter the Italian legal system. So, Italian district courts continued to adjudicate on these cases. And then we have, this was the idea of this kind of position by the Constitutional Court, was to launch a changing in the trend in the international customary law. So to start changing a bit, so it was the ambition was having a starting point of a change in the application of this rule of state immunity from jurisdiction, affirming a human rights exception, let's call it like this. And we have some other cases. For instance, the so-called Korean Comfort to Women case in Korea, the judgment of a Korean district court, so a national court, denied immunity to Japan in a damages action brought by victims of the system of military sexual slavery operated by Imperial Japan during World War II. We have famous Shangri-La case versus Germany, Brazil. So sinking of a fishing boat in 1943. And last but not least, we have a case law of the Ukrainian Supreme Court on this action for damages for what happened for damages caused by Russia in 2014. There are, and I'm approaching the conclusion, a few critical aspects of this litigation. So even if so the first one is discussing this human rights exception. Is not already achieved this change in international law. There are states which frankly criticized the position of Italian Constitutional Court. Here my mind goes to the House of Lords UK judgment in the case Jones, Mitchell and others versus Saudi Arabia. They said, basically they just said clear words against the judgment of Italian Constitutional Court. And this judgment of House of Lords has been finally, let's say, upheld by the Strasbourg Court in a judgment of, no, not Grand Chamber, simple chamber of 2014. But still, the Strasbourg case law is consistent in this regard. There is no human rights exception. The state immunity from jurisdiction does not violate right of access to a court, according to Article 6 of the Convention. And Germany instituted another case before the ICJ, after the one decided in 2012, complaining of continuous violation of immunity from jurisdiction by Italian courts. Not the only problem. We have just had quite a few problems with this type of litigation. First of all, where to bring the case? In our situation, we should think mostly of Ukrainian courts. But we could also think of universal jurisdiction, also on civil matters. So we could imagine that bringing the case, so suing Russia against, I don't know, Italian court. But the universal jurisdiction is not accepted. It's not accepted by Italy. So on the one hand, Italy say, yes, we set aside this immunity from jurisdiction, where there is need to offer a redress to victims of gross violation of human rights. But on the other hand, Italy say, no, but I do not accept universal jurisdiction. So there must be a link, ratione loci, with facts between the actions, the fact that you come before a foreign state and your action. Then, and here we get back basically to the reason of state immunity from jurisdiction. Can we assume that the court of a state is acting as an independent and impartial judge? Isn't there a risk that judge is actually playing a political role or is fighting a political battle against Russia? Isn't there a risk that this human rights exception and this kind of litigation entail a paradoxical situation in a given legal order? For instance, in the United States, it's basically impossible to bring a civil action for actions or violations perpetrated by military troops, US Army abroad, because they enjoy full immunity. But there is this terrorism exception to jurisdictional immunity of a foreign state. If the state is considered the sponsor of the terrorism, then you can sue it before US courts. So we have judgments against Iran for 12 September, for the 11th September support. And isn't there a risk that such actions contribute to inequality among victims of the same violations? Those who take steps will be treated better. Those who are more equipped, legally assisted, will be treated in a better way than those who are not acting. Finally, but as always, I took too much time. Even if you have a judgment, an award of damages, then there is the issue with enforcing the judgment. For instance, if we think of the Ukrainian scenario, we should think of having enough Russian assets in Ukraine, or cross-border litigation, so enforcing judgment award of damages in Ukraine, in other states where there are the Russian assets. But again, I cannot comment this slide, so I'll go very quickly. Again, let's bear in mind that there is not only state immunity from jurisdiction in courts, but also from enforcement, which is even more strict. And there is an interesting case law. I will then send you the presentation of Italian courts on this. So, my conclusion is, I would like to understand what does it mean in times of war, the law falls silent, which is old maxim. Of course, we cannot use this to excuse of all type of human rights violation. It rather means that war tried to keep silence and ineffective human rights which are on legal texts. And as lawyers, we just have to try to find the good way to restore victims, the more appropriate forum, the more suitable legal remedies. Thank you for your attention.
Thank you very much, Francesco. And well, now I'd like to invite our next speaker. It's Kateryna Latysh, and she's an associate professor of criminalistic and deputy head of the criminalistic department of science at Yaroslav Mudry University in Kharkiv. She's also an advocate and member of the International Criminalist Congress and International Association of Penal Law, member of the Council of the Lithuanian Scientific Society, and member of the Council of the Support Project and Research NLU. She has more than 20 scientific publications, 12 years of legal experience in the investigation process and courts, and 8 years of academic and teaching experience. Recently, she was awarded by MSc A4 Ukraine program for the European Commission and will work on research project on the topic digital forensic, open data source, and artificial intelligence as tools of international security. And she also was a project manager in Kurk Lietuvai, so Create for Lithuania project, which explored universal jurisdiction as a tool to achieve justice for Ukraine war victims and offered, a universal jurisdiction toolkit for the pre-trial and trial. So, yeah, Kateryna, the floor is yours. I hope technologies will serve you well.
Thank you so much. It's always when we are speaking about technologies, technology doesn't work. Thank you. Thank you so much for having me here. It's a big honor, honestly, to be here and to present, and especially big gratitude for all of you, especially for foreigners who are coming here to speak about Ukraine, about all these justice issues and other related with Ukraine. Thank you so much for that. And I will tell more about universal jurisdiction and tell why I see that it could be a crucial tool for justice in prosecuting crimes in Ukraine. I'm sorry. Somehow, okay, it works. We speak a lot about ICC and about challenges which we have on that, and also I should mention that it has limited jurisdiction, and we couldn't. This institution couldn't consider all crimes, all war crimes which we have in Ukraine. Of course, it shouldn't, because in accordance to principle of complementarity, we also have our national courts in Ukraine. But there are also some challenges, for example, lack of judges, almost 52%. Also, some of the courts situated on occupied territories and with destroyed facilities. Also, hopefully we will have special tribunal, but it would be only for crime of aggression. I will not speak about it because also we have distinguished speakers who are mentioned about all issues which we have with regard to special tribunal. And for that reason, I consider that universal jurisdiction could be a crucial tool to overcome all these challenges. And frankly speaking, all have heard about universal jurisdiction, but not a lot what actually it is. I mean, not among, of course, international lawyers, but I mean from other lawyers, for example, national lawyers. And universal jurisdictions allow any country who have the right law to have this jurisdiction regardless where crime was committed, the nationality of the victim and the nationality of their perpetrator. Of course, there are two kinds of universal jurisdiction, and in some countries we couldn't have it if we don't have perpetrator on the territory. But in some countries we have this process in absentia. For example, in Lithuania we have it. And also the reason why I consider the universal jurisdiction is a proper tool in that case, because of the numbers of crimes we have already heard and see, so the statistics and numbers from General Prosecutor's Office of Ukraine during our report of Professor Tsybulenko, if I'm not mistaken. But also we should see that these terrible numbers of victims and on the slide, and also some of them actually civilian foreigners and from 24 countries. There are no separate statistics how many foreigners among civilian victims we have, but from my account also from since 2014, also taking in account MH17 case, we could count it as it mentioned on the slide. But of course we should take into consideration that the numbers mentioned above could be really higher, much more higher. And then we made research how many countries now use universal jurisdiction for crimes committed in Ukraine. There are at least 20 countries. This information was collected by me from a General Prosecutor Office of Ukraine, so it's reliable, it's not just from open sources. And I would like to start with this group of countries: Lithuania, Poland, Latvia, Estonia, Slovakia, and Romania. Because all these countries, and Lithuania was the first one who initiated in March 2024 this joint investigation team, where other countries joined. And the first time of the history, I think ICC also joined to this joint investigation team, and also Eurojust as well. And as a result, to regulate some challenges, of course, it's not. There are some challenges how to react with JIT, how to collect evidence. How to share actually this evidence, as far as we have so many countries in JIT, and each of these countries has their own legislation, criminal legislation. So of course there are a lot of challenges, and we should know about it. And for that reason, just in May 2023, there was a conference, Ljubljana and the Ljubljana Hague Convention was adopted, which also established some rules how it should be, how the joint investigation team supposed to react. And also we have some guidelines which was proposed by Eurojust. And then later I will tell you more about communication and integration with NGOs, because firstly, and of course about evidence, because we also arise this question how we could collect evidence when we don't have access to the territory, when we couldn't go, for example, somebody of speakers speak about Syria, when we don't have this access, how we could react. So here we could see, I think, perspectives and really good results as far as we have even ICC here. And Then we have Germany, Belgium, the Netherlands, France. I will not go through all the countries, just mention that there are some countries which have already had a very successful experience. For example, in Germany, in Syria case, there were also efforts of a joint investigation team of JID. It was JID, German-French JID, and so basically these mechanisms are working. It's not just on the paper, and I think we will see a great future of universal jurisdiction, and I will show why I'm thinking about that with the help of this graphic. When I analyzed the trial database, which collect all universal jurisdiction cases around the world, which they found, we could see that 22 countries use universal jurisdiction, and we could see that since 2014, the number of cases of universal jurisdiction are growing and almost twice. And also, if we come back to the previous slide, we could see, and compare with this slide, we could see really new countries who join to universal jurisdiction mechanism for crimes committed in Ukraine. So basically, I think it's also could prove this theory, this thesis that universal jurisdiction could be considered as an essential tool. Of course, not as a single one, but one of them. The next one, why I think that it's very important that in that cases perpetrators wouldn't feel themselves like safe in all countries. For example, traveling around the world, they wouldn't have this so-called safe haven. And then the second one. With the help of universal jurisdiction, with the help of this JID, we could bring together leading domestic, as far as in universal jurisdiction it's mostly about national law enforcement bodies, national judges, and of course to combine it with international practice. For example, in Ukraine, of course, why I'm talking about Ukraine, because there are more architecture for this universal jurisdiction, as we saw before on other slides, and also we have some groups like leading international groups which united international experts. I also told you about it a little bit later. And the third one is digital evidence collection, and this is the answer to the question how we could collect evidence in the territory where we have armed conflicts, when we don't have access. But we could use OSINT, we could use digital tools, and really NGOs, a lot of NGOs are doing really well job on it. And here I put the investigation process in a somehow scheme, just to show you how it could be architected. And here you could see, I told her already about JIT, about prosecutor's office, like in the national levels, ICC, Eurojust, and also we have this third circle, Atrocity Crimes Advisory Group, which was created in May 2022, I'm sorry, by the European Union, by USA, and Great Britain. And there are more than 42 international experts who are consulting also prosecutors' office in Ukraine and other prosecutors who are involved in investigation process, as well as the judges who are participated in these court considerations in Ukraine, because we have really small practice, but as for now, as far as I know, it's around a little bit more than 20 court decisions against Russians, and most of them, of course, in absentia. And with regard to digital evidence, which I have mentioned about, which we could, what kind of tools, digital tools we could use to see and to collect evidence. For example, it could be satellite images. And we saw in the case of Bucha, sad known case in Bucha when it was deoccupied and Russians said that it was all these war crimes, all these murders were committed by Ukrainian soldiers, not by them. And with the help of satellite images, we could prove preliminary, at least, that the bodies appeared during Russian occupation, not when they deoccupied this territory. And so basically it could prove one of the elements of crime. And I know that there are more another situations when these satellite images help to prove preliminary, of course, the time when the crime was committed and some other context of the conflict. Then also I know that in ICC there is a practice on it a little, but still I think in a Ukrainian case we will see more how it's regulated. And the second example which I would like to provide you, it's official monitoring of radars or systems. I know that everybody knows fly radar system, and also we know about this case with Ryanair and Belarusian, and again come back to Ukrainian case and stolen grain by Russians, how we could investigate it. Also using these marine traffic vessels, we could see the road and we could see what kind of vessel crossing, and then we could go to social media and to find the real pictures, for example, people published, and there is even the main person of this. There was a case when the main person, like captain of this vessel, was made a selfie just behind this vessel. Of course, then after it was exposed, he deleted from social media. But what we have in internet never will disappear. We very well know about it. And to prove again this thesis, I have fresh example. It's in November 2023, so this month. Global right compliance, I think a lot of from you knows about it, and they also collect information, digital information, how Russians stole this grain, and also with the help of satellite images, with social media, and so on. So basically, it's an open access. You could, who are interested, could also read about it. So to conclude, I consider universal jurisdiction, that universal jurisdiction could be one of the ways for future of international criminal law. It could advance international accountability system, and perpetrator would have less option to find the safe haven. More countries can contribute to justice projects, not just who are participating in ICC. And with what tools is with digitalization of the evidence collection. Thank you so much for your attention. That's all.
Thank you very much, Kateryna. And without any ado, I would like to invite our third speaker on this panel. It's Gustavo Minervini, who is a postdoctoral research fellow and adjunct professor of public international law at the University of Torino. He holds a law degree from University of Napoli, Federico II, and also PhD in economic law from the University of Napoli. His research interests span international investment law and arbitration, international human rights law, international criminal law. He has published in several prestigious international law journals. He visited as a visiting professor a lot of universities, and also he spent 6 months at International Criminal Court carrying out his research while assisting Judge Rosario Salvatore Aitala. And he also will be a visiting from December 2023. He will be a visiting research fellow at the World Trade Institute. And he's also Italian qualified lawyer, passed the Italian bar exam, and currently on Erasmus trip in our university, and we are very happy about it. Gustavo, the floor is yours.
Thank you very much, Professor Zilinskas, of course, for your introduction, and good afternoon, everyone. First of all, let's say as it's customary, let me thank the conference conveners for having organized this stimulating, this timely event, and of course for their kind invitation. I'm very happy to be here back, let's say, at Mykolas Romeris University after a couple of years. Okay, now it's working. So, as you will probably have understood from the title of my presentation, I will focus today on some legal issues that could arise in case the incumbent president of the Russian Federation will stand a trial before the International Criminal Courts. No, there's no presentation. The International Criminal Court, indeed, following the warrant of arrest that was issued by Pretrial Chamber 2 of the International Criminal Court on 17 March 2023, we cannot anymore exclude that such a trial might actually take place. Now, before delving into, let's say, the substance of my intervention, a couple of brief remarks concerning the warrant of arrest. As many, I would say, of you will probably know, this is not the first time the ICC issues an arrest warrant against an incumbent head of state. Back in 2009, indeed, the ICC issued one against the then incumbent president of Sudan, Omar al-Bashir, a decision that sparked a lot of debate, both in scholarship and in jurisprudence, and it is also known as the so-called al-Bashir saga, which, I mean, I cannot focus on it, but just to say that, in my view, this saga shows how much difficult can be prosecuting a head of state, both legally and, I would say, politically speaking. And this, in my view, might be even truer, and I'm, of course, sorry for saying that, if we consider that, of course, Putin is the head of state of a permanent member of the UN Security Council, which means that no involvement from the UN Security Council might be expected, and which is also, of course, a nuclear power. Then a second consideration, which is related to the, let's say, the scope of the warrant of arrest, according to which Putin is allegedly responsible for crimes of deportation and unlawful transfer of children from Ukraine to Russia. I think we are all aware. I would say that much, maybe too much, has been written concerning the selection of charges because, in my view, at least since probably none of us had the chance to read relevant documents, any conclusion in this respect, it seems to me a bit untimely, even because we must not forget that other arrest warrants could have been issued against Putin without them being publicly available. So let's say that starting from these two consideration assumptions on the warrant of arrest, I will cover two topics which are strictly related to this, to the warrant of arrest itself, sorry. A substantive and a procedural one, to be more precise. First of all, I will deal with one of the modes of liability that have been resorted to as a way to catch the alleged criminal responsibility of Vladimir Putin, namely command or superior responsibility. And second, I will focus on customary international law rules on immunities that a head of state enjoys and their possible interaction with both international crimes and the jurisdiction of an international criminal tribunal. Now, starting with command or superior responsibility, its rationale, I would say it's quite clear. irrespective of whether the subordinate is held accountable for the actual commission of a criminal act, the commander or the superior should bear personal criminal responsibility for its failure to prevent or punish the acts of the subordinates, of course, if any failure is deemed to have taken place. This customary rule, which has developed, I would say, following World War II, has been then codified, despite some relevant differences, in Article 28 of the Rome Statute of the International Criminal Court, according to which command or superior responsibility requires 4 elements. First, the existence of a superior-subordinate relationship, be it de jure or de facto. Second, the superior's, let's say, knowledge or constructive knowledge of the fact that the subordinates were about to commit or had actually committed an international crime. Third, the superior failure to take all reasonable and necessary measures to prevent the commission of the crime or, following the commission, to proceed to punish the subordinates. And fourth, finally, the very much, I would say very much debated existence of a causal link between the failure to act by the superior and the crime committed by the subordinates. Now, moving to the application of these modes of liability, this mode of liability to President Putin, the first question, in my view, to be answered concerns whether he should be considered as a military commander rather than a civilian superior. So if its responsibility might be covered under Article 20A, letter A of the Rome Statute, or under Article 20A, letter B. This is a rather relevant issue. I mean, it has been much discussed if this distinction does even exist under customary international law. I would say no, but let's say that it does exist, or at least it is relevant for our purpose, since we are discussing the ICC statute and any possible trial before the ICC. It is a relevant question because the requirements for criminal responsibility of a civilian superior are stricter than those concerning a military commander, and this is particularly true concerning the superior knowledge or constructive knowledge of the crimes. Now, if we look at the warrant of arrest, the one issued in March 2023, we can say that a choice had been, or of course, temporarily made by the prosecutor, letter B. So it's superior responsibility, civilian superior responsibility, not military commander 1. Of course, I don't think, once again, we have enough information to properly assess this decision, but I was very interested in a different question, which is, could be Putin considered a military commander? In my view, the answer is yes, it is possible for different reasons. Let's just focus on a couple of them. De jure, I would say, under Article 87 of the Russian Constitution, the President of the Russian Federation, and I read, is the Commander-in-Chief of the army. So, under the Constitution of Russia, Putin is the Commander-in-Chief of the army. And then there is also a de facto reason, because I would argue at least, that the very centralized, to call like this, if not dictatorial management of decision-making, also in relation to armed conflict activities, can be used to argue that Putin does exercise an effective military control over Russian armed forces. Now, having said that, of course, let's focus on the question, on the most urgent question, so whether the 4 requirements set forth under Article 28 of the Statute can be prognostically seen as fulfilled with respect to the crimes of unlawful transfer or deportation of Ukrainian children. Now, as for the first element, which is the existence of a superior-subordinate relationship, I would say that this can be more or less easily fulfilled, since as at the head of state and the commander-in-chief of the Russian Federation, I don't see many arguments to say that Putin does not exercise, is not in particular with regard to both soldiers but also civilians involved in this mass crime, does not enjoy a superior-subordinate relationship. As far as the second element, which is, once again, knowledge or constructive knowledge of the crimes committed, I believe that proper knowledge could be proved in this case if we look at some statements by the Russian president himself. However, knowledge is also always a matter, let's say, a complex matter. So if this is not the case, or if we think that knowledge cannot be proved, I would say that still we can prove constructive knowledge, since we are not discussing an isolated, let's call battlefield crime. We are discussing an alleged mass crime that does necessarily require an intense planning, I would say, at the highest political level. Moreover, we have the well-known involvement of Maria Lvova-Belova, the Commissioner for the Children's Rights, in the very office of the President of the Russian Federation. So I honestly can't see how Putin could argue that he knew about the crime. Now, when considering the third requirements, namely the failure to take appropriate measures in order to prevent or punish the conduct, it seems to me that almost we can say that Putin is supportive of this practice. There are many, in my view, elements in this respect. I would limit myself to mention the fact that the Kremlin spokesman, Dmitry Peskov, has repeatedly told that by abducting them, Russia is actually saving children from the scourge of warfare. What is, let's say, the most complex element, at least in my view, concerns indeed the causal nexus. Now, as I was saying, the very need of a causal nexus under customary international law is much contended. According to the majority of scholars, this is a requirement almost only existing under the Rome Statute of the International Criminal Court. Why is this problematic? Because, as you will easily understand, a failure to repress a certain conduct can never be, properly speaking, the cause of that conduct itself. It would be impossible. It's like something that comes before, and thus, from a purely logical point of view, I don't think that failure to repress can be considered as causing something that had already happened. However, I would say that a causal nexus can still be found in this respect if we interpret the failure by the president to condemn, to take all the necessary measures and to set up, for example, a mechanism for prosecuting it as enhancing the chances of future crimes, the same future crime, being committed. So let's say that by this very prima facie assessment, it seems to me that command responsibility might represent an effective tool for prosecuting Putin. Now, moving to the second issue, that is to say whether President Putin could be lawfully arrested, brought, or tried before the International Criminal Court, any discussion must start from the international law of immunities. Since I'm sure that most of those present are well familiar with this field of international law, I will only dwell upon some key points. Now, under customary international law, the supreme organs of a foreign state are entitled to jurisdictional immunity, according to which a court cannot exercise its criminal jurisdiction over the supreme organ of a foreign state unless the latter consents to it. In this regard, scholarship, but also jurisprudence, has traditionally distinguished between personal and functional jurisdictional immunity, with personal immunity is being considered as an immunity from proceeding, which is granted to supreme organs of foreign states only during their mandate for any acts they might have performed. In other words, let's say, whatever the conduct held by the organ, he or she cannot be criminally prosecuted until the mandate comes to an end. Functional jurisdictional immunity, indeed, on the other hand, can be seen as a sort of immunity from the law, which is granted to the organ both during and after the mandate, but only for those acts performed in the exercise of his or her own functions. Put it otherwise, whenever the conduct is held by the organ in the exercise of his or her functions, he or she must not be prosecuted even when the mandate comes to an end. And let's say the only subject to be held responsible for any violation of international law will be the foreign state. Now, having sketched out the regime concerning personal and functional immunity, it is possible to try to understand how they work when international crimes are at stake. So we are not discussing any kind of violation of international law. We are discussing violation of jus cogens rules, or international crimes, and even more when the alleged perpetrator would be or might be prosecuted before an international court or tribunal. As a matter of clarification, I would say that President Putin enjoys both personal and functional immunities since his mandate is still ongoing. Accordingly, if we only look at the rule we have right now pointed out, he should be currently immune from any criminal proceedings of any kind, and in the future, if his mandate will come to an end, he should also be immune from the law as far as all the official acts carried out in the exercise of his mandate. Now, of course, this situation would be almost inadmissible because we cannot think that there are no exceptions when international crimes, such as the crimes he is accused of in the warrant of arrest, war crimes and crimes against humanity, are at stake. However, and unfortunately, I would say the case, or let's say the law is not so clear, or at least is still developing in some respects. Under customary international law, I would say that there is a well-recognized exception, a well-recognized idea that international crimes trample functional immunity. But this is, however, not true, or not at least for everyone true, with regard to personal immunity. Accordingly, a former head of state can be prosecuted for international crimes by either a domestic or an international criminal tribunal. Let's say, to put it straightforwardly, that immunity from the law does not cover any more international crimes. The Pinochet, okay. Thank you. The Pinochet and Milosevic cases are enlightening in this respect. The same does not appear, in my view, to be, have been established under international customary law as far as personal immunity. There is, of course, a very important debate, but I don't see enough state practice and opinion juris to conclude that such an exception did come into existence. Couple of brief remarks, and then a conclusion on the two issues. Now, we could see that the matter is mooted, is done, in the sense that there is this immunity, this personal immunity. However, if we look at the Rome Statute of the International Criminal Court, we will find Article 27, which has been traditionally interpreted as an exclusion of any jurisdictional immunity before the ICC, both personal and functional. In this respect, so someone could say we can prosecute Putin before the ICC because the founding treaty provides so. In this respect, two considerations. First of all, the ICC is the product of a treaty, and one of the most important principles of treaty law is the fact that a treaty does not create obligations for a third state without its consent. So Article 34 of the Vienna Convention on Law of Treaties. So we can interpret Article 27 as a waiver of immunities, but only for those states who have accepted or ratified the statute or the court's jurisdiction through an ad hoc declaration. A second consideration then concerns the thesis put forward by some authors, according to whom the International Criminal Court, being a truly international court or tribunal, can be deemed capable of exercising its jurisdiction even toward third states official. It would be, let's say, a different exception to the rule of personal immunity, which would only cover this truly international court or tribunal. I don't think, once again, that we have enough state practice or opinion juris to claim that such a rule exists. And even so, I see another problem, that this truly international exception, in my view, would cover only the vertical relationship between the court itself and the third state. Why is this problematic? In my view, this is problematic because, as you will all know, the ICC is not provided with a police or a law enforcement force. So to carry out an arrest, the court must rely upon the cooperation of state parties. To carry out, in other words, let's say like this, even accepting the exception according to which a truly international criminal court can disregard personal immunity, Putin would still enjoy personal immunity vis-à-vis all states that are party to the International Criminal Court. Then we would have a sort of court which could prosecute him, but there would be no state that could lawfully arrest and surrender him to the ICC. I see that my time is expired, so just two brief, very brief remarks on the first and the second issue. As far as command responsibility, I thought, and I think, I still believe that it might be useful with regard to the crimes that have been, let's say, selected by the prosecutor. I have also spent a lot of time thinking if we could use this mode of liability to catch responsibility for, let's call, battlefield crimes, torture, murder, pillage. In my view, I have, this is far more difficult. I'm more skeptical in this respect for a couple of reasons. First of all, the famous or infamous geographical remoteness decision requirement endorsed by the appeals chamber of the ICC in Bemba, namely the idea that a political leader might be far away from the battle, so it might be very difficult to link him to action carried out by the troops. And so I see, and of course I also see some practical evidentiary motive. The discussion is even more complicated with regard to immunities. My personal conclusion in this respect is that under customary international law, Putin still enjoys personal jurisdictional immunity as long as he remains in charge. Thus, he should not be arrested. Of course, this does not mean that state cannot arrest him. I would say that it's not by case that Putin decided not to travel to South Africa in 2023 for the BRICS summit. So state, of course, might violate rules on immunity. I don't like any kind of violation of international law, but of course, this is always possible. Last, and that's, I hope it will be some more hope for the future, international law is like this now, but this does not mean that international law cannot change. Quite the opposite. Tragical events such as the aggression against Ukraine have the power to represent a turning point. I found very interesting, and I completely agree with what Francesco said about the law of immunities, which have been under, let's say, contestation in the last 30 years, jurisdictional immunity for states, Greece, Brazil, Italy, South Korea, and even Ukraine. Functional jurisdictional immunity has been set aside. So what about personal jurisdictional immunity? Do we have anything? I would say little until yesterday, or maybe 2 days ago, because on 15 November, a French court issued a warrant of arrest against Bashar al-Assad, the incumbent president of Syria, arguing that no immunity can bar the prosecution of international crimes. I still hardly believe this is currently a rule of international law, but let's hope that this decision might represent a sort of tile of the mosaic for a future possible exception to the rule on personal immunity of heads of states. And that's all. Thank you very much for your attention.
Thank you very much, Gustavo. So yeah, I'm sorry for trying to speed things a little bit up. But still, I think we might take a couple of questions and then perhaps shorten the break, because I'm still waiting for one of the speakers to turn online. And yes, so please, if anyone has questions on these. Yes, Charles.
Thank you. Could I throw another small pebble into the pond on Putin, which could cause a difficulty? There is a subtle difference between the ICTY statute and the ICC statute. The ICTY statute refers to, when talking about knowledge, if he knew or had reason to know that the subordinate was about to commit such acts, future, or had done so, past, and the superior failed to take the necessary and reasonable measures to prevent such acts. The ICC statute is phrased slightly differently. In 28B, and I have to put my hand up and say I helped to draft this, it says, offences committed by subordinates under his or her effective command, the superior either knew or consciously disregarded information which clearly indicated that the subordinates were committing, present, or about to commit such crimes, future. The old principle that if a crime had been committed and it came to your knowledge afterwards, that you had a responsibility to take action to repress, has now gone from the International Criminal Court statute. It must be offences that you knew were being committed at the time or were about to be committed. Then there comes a responsibility to take action to try to prevent. If you fail to do that, you are still under an obligation to repress. But it's a double obligation. It's slightly different from what it was in the ICTY.
Gustavo, please.
Can you hear me? Okay. No, I would say that this is indeed one of the main problems, which is also related to the causal link. So how can we prove that a failure, I mean, that's why I was also a bit surprised by the choice to go through civilian superior responsibility instead of commander responsibility. How can we link the failure to take any measure to repress the crime, to punish the crime, as something causing the crime itself that has already happened? That's why, in my view, this is the most complex issue. And I would say that the only chance I see is rather looking at future crimes, like saying the fact that you did not punish the old one is not a failure to punish, let's say, the first crime, but is a failure to prevent a second crime. So we are actually, I hope we are not circumventing the law, but like my point would be the first crime itself, let's say, cannot be punished because, of course, as Professor Garraway pointed out, this would not be covered. But then as soon as you fail to repress, to punish the first crime, then you are not only failing to punish this because it would be relevant, but you are also failure to taking positive measures against a second crime. And that's, in my view, a way we can try to circumvent. Of course, I had like a sort of limited time, but thank you, I completely agree. I hope I have addressed this point.
Yes, any more? Because I have also a comment from Professor Lyra Jakulevičienė. She's watching online. It's our dean, but she was not feeling well. That's why she had to leave the conference. So it's perhaps for Francesco that even, and she said, even if judgments of European Court of Human Rights might never be executed, recognition of violation is extremely important for victims as remedy, thus should not be underestimated even if justice comes late. So I guess perhaps we all agree, but maybe you have some additional comments.
Just 30 seconds. Of course, I just wanted to underline that when we talk about judgments of an international court, because sometimes it's misunderstood. The judgment is binding for the state, but there is not like an international police or a bailiff who can enforce the judgment. For international court, you need cooperation of states. Still, I don't want to undermine the importance of finding of evaluation, but as a civil lawyer, I rather prefer something effective, something which then can be, which has an impact on the real situation. That's why I said, well, let's not speculate too much about these future judgments of the Strasbourg Court as concerns their execution. Thank you.
Okay, thanks a lot. And I also have one more thought for the discussion on immunities and things like that. If I remember correctly, when the rebellion in Syria has evolved into full civil war, there were kind of decisions by some European countries not to recognize Assad as a legitimate president. So would that might affect any way immunities, let's say in the case, if we talk, let's say, about Putin or about any other dictator? How do you think how these things can play in this issue? Or is it just a matter of de facto ruling, let's say, de facto control of the country?
Thank you for the question, Professor Zilinskas. Of course, this is a relevant issue. I would say that as far as international law is concerned, effectiveness is always like the relevant criterion in order to identify a legitimate government. I mean, legitimate, at least from my point of view, sadly enough, I would say it doesn't mean democratically elected. Otherwise, we would have many countries in the world which have no legitimate government. So, which, I mean, we could argue that might be something, let's say, we would like to, but I currently believe that international law is rather focused on effectiveness. So the government who is capable to exercise its powers effectively and independently upon a certain territory. So in my view, at least as far as Putin is concerned, I mean, it could be an argument, but I would say that from an international law perspective, I would strictly remain to the idea that he is the legitimate head of state, and thus, sadly enough, like he enjoys these immunities, in particular, ratione persone, personal immunity.
Okay, thank you very much. Yes, Thomas, please.
Thank you. I don't know if you heard, but there was a Kuala Lumpur War Crimes Commission, and it had found guilty George W. Bush for war crimes committed in Iraq. So they based their decision on command responsibility, and what's interesting for me and what bothers is that I was thinking, would there be any way to try him again for the same crime, as it's double jeopardy, it's prohibited? And I was thinking about Putin and the universal jurisdiction and his, let's say, friends in Africa or somewhere else who would just pretend to find him guilty, and then the next day the president of that country would pardon him from that crime. And would International Criminal Court still have tools to implement justice?
Well, I mean, this is actually an issue, of course. I didn't know about this commission, so the commission, right? The commission, so thanks, of course, for pointing out. I would say that there is indeed in the statute a reference to the fact that complementarity should be assessed in a sort of good faith compliance with it. So I would say that any fake trial would be considered useless for the purposes of blocking complementarity under the Rome Statute. And I also would say that double jeopardy, which is a fundamental principle of criminal law, has been traditionally not very much, I still see some problems when it is a matter of states' relationship. There are many cases also within Europe with countries that do not recognize other decisions, other criminal decisions, as decision triggering the double jeopardy. So double jeopardy has been, at least as far as I know, I'm not an expert, but traditionally very much located within the domestic system rather than in the interstate relationship. But of course, it is a matter we can consider. At least the ICC has some antibodies. It's like this, antibodies. Or that's my immunity system.
Okay, and one more comment is coming from Professor Tsybulenko from online. So, Evhen, if you can, yes, please connect your microphone and please give us comment.
That's my
sound.
Okay,
one more comment. From your microphone. Please give us
Yes, thank you. Can you hear me?
Yes, we do.
Hello?
Yes, we hear you. Yes, we hear you. Please proceed.
Thank you. Can you hear me? Okay. Thank you very much for Gustavo, his very nice presentation, but I should say that I would not agree with his interpretation of Article 27 of ICC and the fact that it's not applicable for the criminals from the countries which are not member state to ICC statute, and Putin in particular, because we should clearly understand, I believe, that it's an obligation to lift the immunities. It's on the countries which should actually arrest the Putin and as to the court itself. So basically, if country which need to arrest Putin is a member state to ICC, I believe it can do it. And also, I think it's a pretty discussable question as to the presence of the customs, as to the non-applicability of immunities, because I believe that many scholars, not all of them, that's true, but still believe that principle free, Nuremberg principle free, it's also nowadays is considered as a customary norm. So I don't think that, at least on that basis, Putin could not be brought to the responsibility. Thank you.
Okay, thanks a lot. Gustavo, would you like to react? Yes.
Okay, so first of all, thank you for your comments. I mean, as far as customary international law, we, of course, disagree in the sense that this is always normal. I'm happy, happy to be here, to hear, let's say, to be here, to listen to different opinions. I still think that under customary international law, there is no space for this exception. Under the ICC statute, in my view, like this interpretation of Article 27, which would then let's say, Trump's immunities also for third states would then make useless Article 98 of the Rome Statute of the International Criminal Court, according to which the court may not proceed, and then there is all reference to the fact that must, in other words, ask a third state to waive the immunities of the national state concerned. So if that interpretation 27 would cover also third state, then in my view, it might be, let's say, a bit like to trump the effet utile of Article 98. But of course, this is just my personal opinion, and I'm happy to be, let's say, that the court will prove me wrong. I would be really, really happy in this respect.
I'm sorry, but I think Article 98, it's more about extradition if person is still on the territory of the country, but if a person is actually visits the country which is a member state, it's not an issue, I believe. But of course, yes, I can admit that there could be different opinions. Thank you.
Okay, thanks a lot. So now I would like now to announce a very, very short break. If you wish coffee or tea, you can please bring back to this room, and we will continue, I think, in 6-7 minutes. Thanks very much for the panel, for Gustavo, for Kateryna, for Francesco. Yes, round of applause. I'm really sorry. It's a pleasure to see you. It's very nice to see you. So, are you ready for the presentation?
Yes, yes, indeed.
Okay. So we will start in a moment. No, the wrong person. Very good. Okay, so it's nice to see those who still endure back. And now I would like to introduce our next speaker. It's Nataliia Hendel, who is a research fellow at the Geneva Academy of International Humanitarian Law and Human Rights and expert at the Support for Fundamental Research Fund in Ukraine. She's a member of Ukrainian Association of International Law and a member of the European Society of International Law, and she holds LLM and PhD in International Law. Since 2011, she teaches public international law at various Ukrainian universities, specializing in international humanitarian law, human rights law, health law. She's also a co-lecturer at the online course studying international humanitarian law. She's an expert and trainer on international humanitarian law in the Ukrainian Red Cross Society, the Training Center for Prosecutors of Ukraine, She's an expert in the working group of the Council of Europe Program for Human Rights Education for Legal Professionals. And with the help of this program, she developed a course on international humanitarian law and human rights. She was a member of Ukraine's Interdepartmental Commission for the Implementation of International Humanitarian Law. So Nataliia, I know that you are on a trip and it's quite a complicated situation, but we are very glad that you were able to join and we are looking forward for your presentation very much. So please, the floor is yours.
Thank you so much. Good afternoon. It's an honor to participate in this discussion, this conference for me. You have undoubtedly seen photos from the Kherson region. They do not convey the horror of what is happening, the catastrophic consequences of the Kakhovka hydropower plant dam explosion. And this is just one, the latest and most telling example of the scorched earth tactics the Russian Federation is conducting, which has been incorporated into its policy of warfare. The consequences of this scorched earth tactic can be seen in Mariupol, Severodonetsk, Kramatorsk, Bakhmut, and other cities that were destroyed by Russia to take them over. The flooding of mines in Donbass by the Russian occupation authorities before the full-scale invasion, the seizure, shelling, mining of Ukrainian nuclear power plants by the Russian armed forces, the violation of all possible standards of operation of the Zaporizhzhia nuclear power plant and the threat to blow it up, the senseless destruction of the Ukrainian energy infrastructure used exclusively for the needs of civilian population has caused and is inflicting severe catastrophic environmental damage and is in over ecocidal war by Russia against Ukraine. Moreover, Russia is a party to all major international humanitarian law treaties, including the Geneva Conventions for the Protection of Victims of War, the first additional protocol thereto, and the Convention of the Prohibition of Military or any hostile use of environmental modification techniques, Edmund Convention. And that did not stop the aggressor. On 6 June 2023, a man-made disaster occurred in Nova Kakhovka in the temporarily occupied territory. IHL provides the greatest protection to dams and nuclear power plants, explicitly prohibiting attacks on installation and works containing dangerous forces. Even when such facilities are used for military purpose, if such an attack is carried out, all measures must be taken to avoid the release of dangerous forces. The explosion of the Kakhovka hydropower plant dam should be seen as part of Russian overall policy of destroying civilian objects and critical infrastructure during hostilities. For the most part, such actions are carried out with a clear excessive use of force that is not dictated by military necessity. Russian aggression against Ukraine has once again demonstrated the catastrophic consequences of war on the environment, and how powerless and insufficient effective international law has proven to be in this case. The prohibition of environmental damage in Articles 35 and 55 of the first additional protocol was a significant but insufficient step to prevent these types of method and means of warfare. And this was evident in the probable explosion of the Kakhovka Dam by Russian agents. The consequences of the probable explosion of the Kakhovka hydropower plant dam by Russian agents meet the criteria of widespread, long-term and severe damage contained in Articles 35 and 55 of the first additional protocol. But such consequences are not criminalized among its grave breaches. As a specially protected facility containing dangerous forces, the prohibitions in Article 56 in the first additional protocol include only attacks, making it difficult to qualify the probable explosion at the Kakhovka hydropower plant dam as a serious violation of this prohibition. The shortcoming of the above article were also evident in the case of the seizure of the nuclear power plants and attempts at nuclear blackmail by the Russian armed forces at Ukrainian nuclear facilities. Also, the explosion of the Kakhovka Dam qualifies as extensive destruction and appropriation of property, not justified by military necessity and carried out unlawfully and wantonly under Article 147 of the Geneva Convention on the Protection of Civilian Persons in Time of War. This qualification, which is not directly related to the environment, is important for applying in the national level. In this case, the inevitability of punishment was for explosion. The Kakhovka power plant dam should be ensured in the International Criminal Court, and the first step to do so have been taken. On the first day after the explosion of the Kakhovka hydropower plant dam, the Ukrainian Prosecutor General asked the International Criminal Court to investigate this violation. Article 8, paragraph 2a, Roman number 4 of the Rome Statute makes this possible. The reaction to the explosion of the Kakhovka hydroelectric power plant dam by the Ukrainian authorities was immediate. All possible resources were mobilized to help the victims and minimize the consequences of the disaster. However, the consequences for the environment are of regional catastrophe comparable to the Chernobyl disaster. Recently, President Zelensky, speaking at a meeting of the European Council, underlined that if there is no strong reaction from European leaders and countries to the Russian crime at the Kakhovka hydroelectric power plant dam, it could give Russian terrorists a nerve to target the Zaporizhzhia nuclear power plant. Moreover, the reaction of the whole international community and the international justice system. This was stated in a statement by the Verkhovna Rada of Ukraine, which appealed to the United Nations, Parliament and governments of the member states, international organizations and their parliamentary assemblies in connection with another act of terrorism by the Russian Federation by explosion, the Kakhovka Dam. The Ukrainian parliament appeals to the member states of the United Nations Security Council to support Ukraine's claim that the Russian Federation has violated the Edmund Convention and requests the United Nations Security General to convene a consultative committee of experts to clarify and assess the actual circumstances and environmental implications. This is a mechanism explicitly provided for the Edmund Convention, which will help ensure an objective and independent determination of the facts surrounding the dam explosion. Unfortunately, a meeting of the United Nations Security Council on 22 June convened to address the consequences of Russian undermining of the Kakhovka Dam and the threat of the terrorist attack on the Zaporizhzhia nuclear power plant was not productive. Only the Parliament Assembly of the Council of Europe has responded to the terrorist attack of the Kakhovka hydroelectric power plant dam with a resolution in the document entitled "On the Political Consequences of Russian Aggression against Ukraine." The destruction of the Kakhovka Dam is recognized as a war crime and ecocide committed by Russian Federation. Ukrainian law enforcement authorities began investigating and documented the crime in the first hour after the explosion of the Kakhovka Dam. Criminal proceedings were opened under 2 articles of the Criminal Code of Ukraine: violation of laws and customs of war, it's Article 438, which is equivalent to war crimes, and ecocide, it's Article 441 of Ukrainian Criminal Code. The Criminal Code of Russian Federation also contains the crime of ecocide. However, there have been no court convictions under this article in Ukraine. It was a dormant article. Moreover, about a dozen criminal proceedings on ecocide have been opened in Ukraine, and the explosion of the Kakhovka Dam is among them. The article criminalized ecocide as mass destruction of plants and animals, poisoning of air or water resources, and other actions that can cause an ecological disaster without revealing the concept of ecological disaster. In our opinion, the criteria of ecological disaster may be linked to the definition of widespread, long-term, and severe damage in the Edmund Convention or as the first additional protocol. Undoubtedly, the consequences of Kakhovka plant dam meet the notion of ecological disaster according to the highest criteria, which could be the first additional protocol, for example. This qualification is legally irreproachable in accordance with the factual circumstances. Additionally, other states may initiate criminal procedure over the Kakhovka Dam bombing, as the principle of universal jurisdiction applies to war crimes. It is important to note that after the flooding of a large area as a result of the explosion of the Kakhovka hydroelectric power plant dam, Russia and its agents committed a number of other serious violations of international humanitarian law and accordingly war crimes: restriction of prohibition on evacuation, denial of access to humanitarian aid, and shelling of evacuation groups should be separately qualified under Article 8 of the Rome Statute and Article 438 of the Criminal Code of Ukraine as war crimes. Also, Ukraine can use the mechanism of the International Court of Justice to address Russian violation of the Stockholm Convention on Persistent Organic Pollutions and the Convention on the Protection and Use of Transborder Watercourses and International Lakes, and another one, Convention, for example, Convention on Biological Diversity. Thus, international law provides for dual responsibility for such action of states' responsibility and individual responsibility, along with the international responsibility of the Russian Federation as state. Both the direct perpetrators who blow up the dam, and the Russian military and political leadership should be held international criminal liability for the Kakhovka hydropower plant dam explosion, either for issuing on an order or on the basis of the command responsibility. The explosion of Kakhovka Dam should be considered as one of the episodes of general crime, which is the destruction of the civilian objects and critical infrastructure by Russia during hostilities. For this systematic crime, the Russian military and political leadership should be held accountable separately at the international level, in particular in the International Criminal Court. In conclusion, it should be recognized that contemporary international law and international humanitarian law, international criminal law as part of it, do not contain sufficient rules and mechanisms to protect the environment during armed conflict. All the international treaties that have been mentioned need improvement, primarily in relation to the protection of the environment and facilities contain dangerous forces. And the international armed conflict caused by Russian aggression against Ukraine will, we hope, undoubtedly lead to amendments to international law, including the addition of criminalize and define ecocide under the Rome Statute in the medium term. And now, on the agenda is the prosecution of Russian agents for all war crimes and crimes against humanity, genocide crime, and crimes against nature. Sincere gratitude for your attention. My presentation is ended.
Thank you very much, Nataliia. So we are leaving questions for after three presentations. So and now, just one moment. Now I would like to ask and to give a floor for Olga Poiedinok, who is an associate professor at Taras Shevchenko National University of Kyiv, Institute of International Relations and Department of International Law. She's also chairwoman of the Public Council at the State Migration Service of Ukraine, member of the board of the State Migration Service of Ukraine, deputy chair of the committees of the National Bar Association of Ukraine on International Law and Gender Policy, as well as chairwoman of the board of the NGO Contemporary Law Studies and member of the board of the Center for Family Law Studies. She combines practical legal work as a lawyer with research and teaching activities. She specializes in citizenship and other aspects of personal status, migrant rights, private international law, including international child abduction and gender issues in international law. As an expert on Ukraine's obligation under international law, Olga cooperates with Ukrainian public authorities, international organizations, and public associations. So, Olga, the floor is yours.
Lawyer specializing in private international law, primarily first in international commercial law and then in international family law, and I dealt with nationality and citizenship issues. Here I will use these words as synonyms. I hope that everybody understands the subtle difference between the two concepts, one of which citizenship is more applicable within the domestic legal order, and the other one, nationality, is more frequently used within the international, public international law context. But I dealt with both of these issues within the peaceful context. And I was very much interested in international humanitarian law when I was a student, and that was like a very theoretical interest. All those IHL competitions, including Jean Pictet competition, and also this model international criminal court stuff. So it was like a very nice theoretical field of studies. And then back in 2014, the Russian aggression started. And so these two roads, they crossed. And here, how I started to work with the issues of the Russian passportization. Speaking about passportization, what I mean by passportization, of course, I mean the distribution of Russian passports in certain territories of Ukraine. I mean Russia's attempts to convert Ukrainian nationals residing in the territory of Ukraine into Russian nationals. Before I start to qualify the acts of the Russian Federation in that field under the international humanitarian law, I would like to address the issue of so-called weaponization of nationality. Because now many researchers talk about it, they publish papers on that issue, so the concept is definitely gaining momentum, and different people mean different things when they speak about weaponization of nationality. Some of them speak about weaponization of nationality stricto sensu, meaning that exactly making some foreigners your nationals in order to give them weapon and go and fight for the newly acquired for the state of the newly acquired nationality. Yeah, but we can also speak about that about weaponization of nationality in wider terms, and we can call it a tool in political games of the states, not necessarily geopolitical games of the states, because, of course, if we speak about the Russian aggression, for instance, we speak about the geopolitical games of the Russian Federation, of course, cruel and awful and inhuman. But this can be used, the same instrument of mechanism of passportization can be used in order to achieve some goals within the domestic realm. For instance, we see the Hungarian example, this Hungarian passportization in Ukraine, in order to get new voters who will be grateful to the ruler who granted this nationality, and that will vote. That is my assessment. Yeah, we can discuss it later on. And of course this. And when I speak about the same issue with my students, the first thing I ask them is whether it is okay under international law to grant your nationality to a national of a foreign state. Normally they say, yes, it is okay. You can grant your nationality to a foreigner, no problem, globalized world, and so on and so forth. Okay, if we increase this number and have 100 nationals, new nationals coming from the same state of origin, yeah, then we increase it to 100,000, then to 1 million, then say, oh, come on, let's stop here. And what is the size of the population of the second state in question? I say 2 million. So where is this? Where is this limit? Yeah, and then we start raise issues about maybe it is an unfriendly act, or maybe it is interference in internal affairs, or maybe it is an evidence of the lack of respect to sovereignty of the foreign state, and so on and so forth. But that is the discussion which is very interesting when we speak about the times of peace. But when we speak about the times of war, about the armed conflict, the context changes. And we remember that formula that was created by the Permanent Court of International Justice, and then repeated in the European Convention on Nationality, that other states have a right not to recognize the way how the foreign state chooses its nationals, or how the foreign state determines this circle of its nationals, if the way the foreign state does it is not in line with international law. And when we open, for instance, the Fourth Geneva Convention, because we're speaking about the occupied territories, we will see that probably the Russian Federation, by means of passportization, is trying to strip the population of the occupied territory, of the occupied Ukrainian territories, of their protection under the Fourth Geneva Convention, because the Fourth Geneva Convention protects the inhabitants who are not the nationals of the occupying power. Then we go further and we see Article 31, and we see that no moral or physical coercion can be exercised against the population of the occupied territory. And we see very, very clearly that the situation, that life under the Russian occupation is far from being easy. And of course there are both physical and moral coercion, and that is evident. And I consider taking a Russian passport as by an inhabitant of the occupied territory as a means of survival. Yes, and that is why when sometimes I hear the discussions within the Ukrainian society about this step, I do my best to persuade that we should not think that these people are traitors. They are just trying to survive. Of course, if we and we all understand that it is also prohibited to ask the inhabitants of the occupied territory to swear allegiance to the occupying power, and of course also we understand that nationality is the first step to mobilization, and we see it how the Russian Federation uses the occupied territories as a resource base, including a base of human resources, when first today it gives its passport, and tomorrow this man becomes a Russian soldier. That is. And so the qualification under international humanitarian law is very simple. Of course, we deal with the violation of international humanitarian law, and when we speak about Article 147 of the Fourth Geneva Convention, so making the people who live in the occupied territories serve in the army of the occupying power, that is a war crime definitely, and this war crime is also included into the Rome Statute. So one final remark I would like to make, and of course I will be more than happy to participate in the discussion and answer your questions. So one final remark is the reaction of Ukraine and the reaction of other civilized nations or civilized states, those states who have respect towards international law. the reaction to this Russian passportization. Of course, the only possible reaction is non-recognition. And neither Ukraine nor the states members of the European Union, nor the United States of America, nor Canada, they do not recognize the results of that Russian passportization. And so the basic principle here is ex in iuria jus non oritur, meaning that law or right does not arise from wrongdoing, and that is the most important, and that is the most realistic solution under the circumstances. But of course, we will have to return to this issue while Ukrainian lands are liberated by the Ukrainian armed forces. But what I see now within Ukraine, it's okay, at least from the legal point of view. And I hope that this approach will not be changed after the end of hostilities and after the entire territory of Ukraine is controlled by the Ukrainian government. Thank you very much.
Thanks a lot, Olga. And now I would like to ask our final speaker. It's Tomas Marozas, who is a lecturer here at the Institute of International and European Union Law. Just recently defended his doctoral thesis, but also managed to do important works before and during. So he was working in governmental bodies with national and international security issues as a researcher at Parliament Research Department at the Office of Seimas, its Lithuanian Parliament, advisor of the Committee of National Security and Defense of the Office of Seimas, then a legal advisor at the Office of the President of Lithuania, and he is one of the authors of the Lithuanian textbook on international humanitarian law and published articles in fields of international humanitarian law, international criminal law, and international space law. So his field of research involves legal issues related to modern armed conflicts, more specifically cyber warfare, satellite targeting, preservation of natural environment, as well as aspects of individual responsibility for international crimes. So Thomas, the floor is yours.
Thank you, Justinas, for introducing me. And I was reminded during the lunch break that it is being recorded, and the record will stay in the internet forever until it prevails. So thank you for restoring my cortisol levels to the right level. Now, indeed, I have a reminder for you. You have QR codes, so don't forget to make donations if it's possible for you, of course. And speaking of Ukraine war, many characterize this war as being somewhere between brutal First World War and the futuristic technologically advanced Third World War. And as Colonel John Bolton described it as it mirrors the past as much as it mirrors the future. So there is nothing more oxymoronic in this war than seeing a distantly controlled drone operated somewhere in the middle of the field, dropping an explosive device on a soldier hiding in the trench. So today I will be speaking about the futuristic side of this war, and namely I will raise the question, should targeting rules apply to anti-satellite operations in Ukraine? Now, let me come back. So at the beginning of the war in March in 2022, around 50 kilometers away from Kiev, Ukrainian forces captured this strange military container full of antennas, and later it was found out that it's the electromagnetic warfare system of Russia called Krasuka-4. So Krasuka-4 system is capable of jamming electromagnetic signals at distances reaching up to 300 kilometers, which means that they are capable of jamming radars, anti-air defense systems, other anti-air systems, even jamming GPS signals, which are often used by smart missiles, and eventually these smart missiles may be converted into the dumb ones. So throughout its activities in Ukraine, Russia has been constantly using these technologies, jamming satellite signals, and sometimes making the famous HIMARS systems not that effective, missing targets as they lose GPS signals. As we know, SpaceX company offered their services to provide internet over Ukraine, but there are rumors that Russia is capable of jamming even this constellation. Now, sometimes, as 2 weeks ago, we may find pretty ironic headlines of famous internet sources, such as the Russians installed a GPS jammer in Ukraine. The Ukrainians blew it up with a GPS-guided bomb. Now, leaving irony aside, it has already happened before. In 2018, during the NATO exercise over Kola Peninsula, where is Norway and Russia border, anti-satellite technologies were used to jam GPS signals, which eventually caused air traffic problems, not only the NATO military aircraft problems, but also civilian. So the air traffic was heavily disrupted. The planes had to land. This matter was brought later on between foreign ministers of Russia and Norway. And eventually, Norway provided undisputable evidence that it was the Krasuka 4 system that was doing that. Now, today I will talk about IHL boundaries, what IHL says about these types of events, and how can they be classified. So first and foremost, we should look at the basic, I should say, targeting rule of IHL, which is codified in Article 48 of the first additional protocol, which we have constantly been discussing today, and we know that Russia and Ukraine are both parties to it, and this rule applies to both of them. And it says that in order to ensure respect for the protection of civilian population and civilian objects, parties at all times should distinguish between civilians and combatants, and between civilian objects and military objectives, and only direct their operations against military objectives. So the essential word here, well, it's evident that targeting civilians is prohibited under IHL. It's the core of IHL. It's the major premise of existing of this branch of law. But we have questions, what does that word operations mean? As we know that current and, well, former, every armed conflict involves psychological operations, and propaganda is actually directed at civilian population to change public opinion, and it's a military operation. So can we consider that this military operation targeted specifically at civilians is prohibited, or is it allowed? Do states apply this rule correctly? Have they been wrong? So, let's question and let's tackle this one at first. Now, to understand the system of targeting rules, it is the best way, logically, to analyze these targeting rules. And really, thank you, Charles Garraway, for presenting those rules. It will make my presentation even shorter. But most of them are listed here. I will not read it. They basically relate to principle of distinction, principle of proportionality, principle of precautions in attacks, protection of natural environment, and so on and so on. But there is a common notion in these all rules, which is attacks. So, as you see, each targeting rule involves not merely military operations, but attacks. So we may question what is attack. And luckily, it's a rare phenomenon in international law to find a definition. The drafters of first additional protocol, they managed to define attacks. So attacks are defined in Article 49. These are acts of violence against the adversary, whether in offense or in defense. So we may question what is violence, because this is the key word that differentiates it from other military operations, such as propaganda. So there are two authoritative commentaries of first additional protocol. One was written by the editor and other authors, Bote, who's been one of the drafters of the first additional protocol. And he connotes that the word violence primarily should mean to physical force. Of course, when we think of violence, it usually means something kinetic, something touchable, like a missile touching at the surface of a military objective, causing explosive power. That's naturally an attack, right? Then ICRC elaborated a little bit more in their own commentary that it's a combat action endangering a person, but they specifically said that the endangerment, if I may say so, should not appear immediately. In other words, they give an example of laying landmines. Sometimes landmines never explode, but the mere laying of those landmines constitutes attacks. So, both commentaries in general say the same thing, that it connotes to physical force, not necessarily immediate. And both of them say that it connotes to violent consequences, not merely violence itself. So if we, let's say, talk about the bacteriological or chemical weapons, we know that the release in itself is not violent usually, but the effects of those weapons are violent. So when we spray Novichok on the door handle of Skripal, we don't blame that it's the handle that is broken. It's the consequences that are caused by that chemical. So to understand what is meant by violent consequences, in my view, the best way is to look at principle of proportionality. And it's codified in Article 51. And principle of proportionality basically says that the military attack planner should evaluate the military advantage of the potential attack in the future and the possible negative effects of that attack. And luckily, this article actually lists those negative effects. And this article says that it's loss of civilian life, injury to civilians, and damage to civilian objects. So again, we face the negative physical consequences. And all that being said, let me just quickly go through these targeting rules. It's really sensitive. Sorry. Okay. So first of all, targeting rules connote to attacks. Not all attacks should be followed by those distinction and proportionality principles, but those which cause violence. And violence connotes to violent effects, and violent effects are injuries to life and injury and damage to property. So again, when we have operation which is about to injure people or damage property, only these operations are subjected to targeting rules. And the circle goes on and on and on, and each military commander should have that in mind. The problem in that circle is the life, injury, and damage, the last part, the part of the principle of proportionality. Because as we know, the modern tools of warfare often do not cause evident violent effects, such as cyber attacks. Most of the cyber attacks actually do not cause any violent effects, at least instantly. And that discussion has been brought by the expert group who were drafting Tallinn Manual, the major document describing how international law should apply to military cyber operations, and not only military. So they said that, well, there is a problem. Not all cyber operations cause violence, and it wouldn't be fair if we just exclude all those operations, even though they were directed at civilians and causing certain certain level of negative consequences from the targeting rules. So they invented this functionality test, according to which, well, a cyber attack should have certain negative effects on functionality of an object, and if the repairment of that functionality requires replacement of physical component, then such military operation is attack and is subjected to targeting rules. In other words, if you create a virus and that virus damages your motherboard somewhere in the computer of a civilian, that attack would be prohibited because civilians, one of the major targeting rules, civilians and the civilian objects may not be attacked. So that's the logic. Now, ICRC, on their own hand, they proposed a rather more wide interpretation of this notion, and they said that there is definition of military objective, and it says that military objectives are all of those objectives which by their nature, purpose, location, or use make effective contribution to military action and whose partial or total damage or destruction, or neutralization or capture offers a definite military advantage. And they said that this definition includes not only damage, but also neutralization and capture. So it would be fair to, to think of attacks, not only those which cause damage, but also those who neutralize objects. So, for instance, the same as laying landmines, it is considered as an attack because it neutralizes a piece of land. It's not usable anymore. Now, one of the most authoritative experts of targeting law, William Boothby, upholds the position of Tallinn Manual, indicating that, well, considering cyber attacks, something physically should be damaged and replaced. Now, Knut Dorman, again, from the side of the ICRC, and there was a really lively discussion from one article to another, and then replies from another article. So Dorman said that, well, neutralization is an element of military objective, and we cannot just escape it and argue that only those military activities that connote to damage are involved. And Mike Schmidt made a response and said that there is a difference between definition of attacks and definition of military objective, and we have this discussion, to be honest, not yet solved and ongoing, and if you are willing to have easy way to introduce your legal thoughts, just grab this one and it would be a really nice way to adding for international law. Now, in my view, the problem is that both views are really, may be criticized. Both views are really advantages, but they may be criticized. First of all, the functionality test, they argued that, as I said, that the repair activity of a physical component. Now, in my view, if I make a cyber virus which can interfere with the code which has been programmed years and years, and the replacement of that code would probably cost more time and money than physically replacing the component, why wouldn't such an attack be considered as, such military operation be considered as an attack? If it still does damage and probably neutralize a server or a web page. On the other hand, if we talk about merely inconvenience, let's say Facebook servers are damaged and I cannot scroll in the morning with my cup of coffee. Is that violence? Is that an attack? Well, obviously not. So we have to look for the answer somewhere in the middle. And again, my solution is just coming back to the purpose of IHL without any functionality or inconvenience considerations. It's just Article 57 has already multiple times been quoted today, requires constant care of civilians, constant spare of civilians. So in my view, this rule requiring not only care of civilians during attacks, but in all the times of armed conflict, it requires a circumstantial approach on each military activity. Basically, it requires to view a target and its relationship with civilian population, and what would happen if that object was targeted, whether civilian population would face these negative effects. So I suggest treating attacks as a way, like each attack should be treated in the way that on the circumstantial based approach, and each target should be evaluated individually. At least that's what the purpose of IHL says. Okay, sorry again. I'm not thanking you yet. So again, let's go to the topic of satellite jamming. And actually, this topic involves not only jamming, but all those soft military means, including cyber attacks. So speaking of satellites, some satellites really serve a huge, well, civilian population is heavily dependent from those satellites, such as GPS or other GNSS satellites, which provide essential commodities like stock exchange markets, our ATM machines, energy current equalization, let's say, in the electrical current equalization, then many other fields where the timing is really important. And as we know, GPS clocks GPS satellites have atomic clocks, which the time of which are used in civilian, many commodities in civilian world. So jamming those signals might cause devastating effects, sometimes even floods, if dams were regulated by the GPS time. So satellites, which are heavily civilians, which are heavily dependent on those satellites, well, before attacking those satellites, one should take into account the type of a satellite and what consequences it may make. So even though signal jamming might seem a military activity not causing violent effects, but it should still constitute an attack dependently from a target. So that's probably it, and I'm really looking forward to the questions. Thank you.
Yeah, thank you very much, Thomas. So now it's time for questions. We still have some 10, 12 minutes, so please don't be shy.
Could you please start with me, because I have to leave really, yeah, in 10 minutes.
In 15 minutes, everything is counted.
Okay,
yes, everything is.
Thank you so much.
Okay, so Tamas, please.
Yes, I will make this very quick, and I promise I'm not going to open now the Hungarian passports in Ukraine issue. Well, we could. Let me just use that for a short point and asking your opinion on that. I do believe, and correct me if you think that I'm wrong, that by these passportization projects and that Russia has been doing in many countries were for a long time, mostly for a jus ad bellum reason, to try to create a fake legal situation in which it can argue the protection of its own citizens, while these people, in most cases, have not necessarily had any genuine citizenship, ethnic, etc. relationship with Russia. I think that is my point. That is my idea. And just a short thing there with the Hungarian passports, you know that most of those people who gain passports are ethnic Hungarians. The Hungarian government, which I find extremely uncomfortable that I would be the one protecting the Hungarian government. I don't want to do that. The Hungarian government does not have the military power or anything like that, doing anything similar than Russia is doing.
Let's hope so.
And basically, which is interesting, that most of these passports to non-Hungarians, not only there but also in Romania, and you may find it very interesting that the whole Hungarian passport and citizenship issue was basically taken over from the Romanian country. Even Hungarian officials were surprised about the amount of passports taken away all over in Ukraine. And yeah, the main reason with the Hungarian government is raising a voting power. But at the same time, you need to know, probably you are not an expert on the Hungarian electoral system, and nobody should be because it's really bad. But the point is that all of the foreign citizens not living in Hungary with a Hungarian passport, all of their votes are calculated into one virtual voting district, and basically that amounts to the maximum of one member of the parliament out of the 200. So basically Viktor Orbán, unfortunately, I say this, is not winning the elections because of that. I wish it was that easy. But the point here with international law is that I believe that the passportization project that you were talking about by Russia is actually being used for some time for an alternative of the use of force in gaining political violence, and then possibly, like you could see that in South Ossetia, in the case of Georgia, that it was used as a sort of a jus ad bellum fake argument for like self-defense and stuff like that. That was my point related to that. Thank you.
Yes, thank you very much. I would agree on that point within the Crimean context. Because in the Crimea we really had many Russian passports long before 2014, because Russia made an attempt to take Crimea back to its hands as a successor of the Soviet Union, like back in 1993. And it was obvious that Russia had been planning something like this. That is when it comes to Crimea. But when it comes to selected regions of Donetsk and Luhansk oblasts, and also to the so-called newly occupied territories, there we had not had so many Russian passports. Never. That was made by the Russian Federation within the course of the armed conflict in order to strengthen its positions in the occupied territories, and then to integrate those territories into the Russian Federation. That is it. But when it comes to Crimea, definitely, yeah.
And do you think that that makes any sense from Russia? I mean, what's the point of that?
That is the point. The point is like humanitarian intervention. Say that that is like stricto sensu humanitarian intervention. We are trying to protect our citizens who suffer from this Nazi Ukrainian government. That is it. I think that is it. But Ukraine could not do anything with that, because what was the solution? The only solution was to deprive, not to deprive, but to initiate the loss. There is no deprivation of nationality in Ukraine. To initiate the loss of the Ukrainian nationality, and so as a result, we would have had the peninsula inhabited with so many Russians and only Russians. Yes, and so that was not a very sound solution. That is why we have this. We have what we have, and that is why we don't. Ukrainian government, as I can see, does not press the issue of stripping dual nationals of their Ukrainian nationality for that particular purpose, not to have huge regions of Ukraine inhabited by foreigners who do not have Ukrainian nationality.
Okay, thank you very much. Other questions? Yes, please.
Okay, you can hear me. Dear distinguished speakers, it's an honor to be here with you. I come from Zaporizhia region, which is now half of the region occupied, and I'm really worried about the passportization process that is ongoing right now. And Are there any ongoing diplomatic efforts or negotiations that aimed at addressing such issues that concern citizenship and conscription complexities? And what role are international organizations play in resolving these issues? Thank you.
As far as I know, Ukraine. Ukraine's position in this field remains the same: non-recognition of Russian nationality acquired by the inhabitants of the occupied territories. And what Ukraine does externally, Ukraine explains to its partners, either foreign states or international organizations, that please do not recognize that Russian nationality, do not accept passports, and the Ukrainian government always reminds that is, first of all, the violation of international humanitarian law, but also the violation of international human rights law, because we consider, as the European Court of Human Rights says, nationality is a part of social identity of a human being. And this passportization is like an imposition of an alien, hostile, new social identity. But in my opinion, Ukraine does everything it can in terms of diplomacy, law, and so on and so on. But in that field. But of course, Ukraine cannot do more, because it does not, its government does not control that part of the territory, obviously, unfortunately. But of course, this aspect will be taken into consideration when all these issues appear before the national courts and international courts as well. Yeah, and Ukraine reiterates on all those points. That is for sure. I follow this agenda, and I can say that the Ukrainian government is doing well.
Okay, thanks a lot, Olga. So perhaps for you to have a peace of mind, so I will allow to leave together with Roman. So thanks again, dear Ukrainian colleagues, for participation. But the others still, Thomas still here, Nataliia, I think, also still here. So do we have, yes, Tamas, question number,
Sorry,
whatever.
I don't want to take all the time and everything, I just want to say something about something that Thomas said, and I wholeheartedly agree. The issue of damages. I do believe that there is something that many lawyers tend to forget when we are talking about software damages. Even if we need to reinstall a system, that requires a working hour from an IT expert. That costs money. That's damage. So I totally agree with your interpretation that there is something needed, a different interpretation may be needed. And basically, I think that the reason why this physical damage requirement was included in the thinking, especially at the very beginning with the Tallinn manual, was that, as this was taking the whole issue quite close to jus ad bellum, it's like, is my right to self-defense is going to be brought up if I'm a subject of a cyber attack, then somehow the drafters wanted to make some physical evidence. And that is why this damage issue was needed. Because if we are talking about just like losing data or something, that can be done quietly, and that can be it can be easily faked. And if a state wants to use the fact of a cyber attack to argue that it has the right to self-defense and use kinetic force in return, which might be, legally speaking, a first act of aggression, then this could be just an easy way. Or at least that is my understanding on how and why this criterion was invented by the drafters of the Tallinn manual. And I think that, yeah, it's another interpretation is needed. So thank you very much for your presentation.
Thank you, excellent remark. And Well, I always think of IHL being a totally separate branch from Jus ad Bellum. So I rarely do connect reasoning and everything else that those two branches have. I mean, they share certain terms like attacks. We have attacks in IHL and Jus ad Bellum, but still they have a different meaning. One invoking right to self-defense, and the other describing when to use targeting rules. So today I try to focus and to, well, basically explain that it's how these rules actually circle around and how they should be interpreted. So even soft means at some point might cause damage. And when we talk about these functionalities, I mean, why would you apply that test if the same cyber attack could cause the same damage, physical damage, even deaths or injuries to civilians? So yeah, but that's probably the reason why this notion was discussed. But even Tallinn Manual, authors of Tallinn Manual, they do emphasize the difference between Jus ad Bellum and Jus in Bello. So they were really aware of that.
Okay. So, any other comments, ideas, questions? Or everybody tired? Okay, so then perhaps I will move to the closing remarks. And of course, the first remark will be that thank you for coming. Thank you for presenting. Thank you for discussing. And it was a very, I should say, fruitful day for all of us, for lawyers to discuss so many things related to international responsibility, to law of armed conflict. And I should say that in Lithuania, we rarely discuss this, except, let's say, in the media when they need to comment on some incident that suddenly happened. And yes, but up to the incidents, nobody is very much interested. So thank you for keeping this discussion alive, and I think it's really important discussion. And also, I would like to thank people who helped a lot to do this conference. And so first of all, it was Olesia, who was now accompanying our guests. It was Thomas who helped me a lot. It was Janetta and Arvydas and all the MRU team, and Thomas, who was another Thomas who was working with all the technical issues. And it's indeed very complicated things to broadcast from Zoom and to film you. So, and yes, as this Thomas pointed out, this video will stay on the internet as long as we have it. So yeah, so you can always rewind and again to relive these discussions. Also, I would like to thank our sponsors. That was Research Council of Lithuania that helped us to bring our dear guests here, and also a law firm Sorainen and its partner advocate Aušra Mudėnaitė. So without those people, without those efforts, the conference hasn't happened. And well, I think it's very important that this topic of Ukraine fight and international responsibility that is much more wider than the Ukraine cause should stay on the line, should stay online, and should stay on the minds of the lawyers. So thank you for keeping this, and hope to see you in the next event. So thank you. Our conference is over.